Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-3023. United States of America versus Oscar Ramiro Ortega-Hernandez, also known as Oscar Ramiro Ortega, appellants. Ms. Millett for the appellant, Mr. Cahill for the appellant.
Good morning, counsel. Ms. Millett, please proceed when you're ready.
Good morning, Your Honors. Courtney Millett on behalf of Mr. Ortega-Hernandez. I'd like to reserve 2 minutes for rebuttal. 1363's enhanced offense is not a 924C crime of violence for, by my count, about 5 separate but interrelated reasons. I'd like to start with what I think is the simplest way for the court to resolve this case, though it's by no means the only way to do so. And that is 1363's offense is not a 924C crime of violence because it can be committed by force against one's own property and by putting one's own life at risk. This is so because of the text of the law as well as its evolution over time.
Ms. Millett, can you talk first about the procedural bar issue here? So Johnson was decided while Mr. Ortega-Hernandez's claim was still pending on appeal, and it wasn't raised on direct appeal. So why should we consider the issue now?
So Johnson came down after his appeal was fully briefed, but before a decision issued.
It was before oral argument. Johnson was decided in June of 2015 and oral argument was in September of 2015, which left plenty of time to file 28J letter, supplemental authority.
So I think the court should look at the 10th Circuit's decision in Garcia, I believe that's out of the 10th, where a similar situation arose. The appellant had not made a Johnson claim and Johnson came down before a decision issued in the case. And the court explained that a 28J letter is not the type of letter one should be using to raise brand new arguments.
So would it have to have been in a 28J letter because cert was granted before, you correct me on the time if I got it wrong, but as I understand it, cert gets granted in Johnson and that's before the opening briefs filed on directed.
So cert is granted in Johnson, but the court actually didn't grant cert on the question that it ultimately decided, which is that the residual clause was void for vagueness. It had argument and then reissued a new question. And that question, I believe, came down in December of 2014, if I'm not mistaken, which is after the opening brief was filed.
Was it before the reply brief?
It was before the reply brief, but after the opening brief. And as we all know, you have to raise your issues in your opening brief. You don't get to raise brand new issues. I mean, and that's a whole brand new claim.
Would you, if that question had been sent out before the opening brief, Johnson had said, the world knows now that we're looking at this question, would you be making the same argument?
I would probably be making the same argument, but I would be in a more difficult position. I think there's certainly case law that talks about procedural default being about the time of the plea, the time at which you're admitting to guilt, rather than necessarily on appeal. But candidly, I just don't think it matters here because Johnson came.
Because we know that the law can change on direct appeal, which is, I think, what Judge Rao was alluding to. The law can change on direct appeal in a way that renders something plain error. So it would be a successful argument on direct appeal, even if it requires the plain error argument, if there's been a Supreme Court decision has come down in the interim that then sets the law in a particular way, or a circuit decision has come down in a particular way.
So that's true. I mean, I don't think it would have been plain error here because Johnson was about ACCA. It was not about 924C. I mean, we're raising a Johnson claim. Johnson animates our whole argument about 924C, and that's why the courts went the way they did on 924C. But that Garcia decision, the court notes that a notice of supplemental authority is not the proper way to raise a new argument, and specifically notes that it would have been particularly inappropriate in that context because unlike in an ACCA case, I mean, Johnson came down and then it was years before it was clear that its rule applied to 924C, even though the logic, was laid down in that court's decision. I'm not sure it would have to be after Davis. We did not wait till Davis. We filed within the time the Johnson decision came down, but I think it underscores the fact that, once you filed your opening brief, and, the Reed decision doesn't talk about when cert's granted. The Reed decision talks about when Supreme Court case law is overturned. So I think the proper point to look at is going to be when the Johnson decision came down, which is after briefing.
And not when the Johnson question came out.
Correct.
I think it's when the.
Correct. But I don't think that, first of all, I just don't think the court needs to decide that for this case, because in this particular
In
case.
order for us to consider the issue, you still have to show cause for us to consider
Yes.
it, because it wasn't raised on direct appeal. And given that, cert was granted and Johnson was decided, how do you surmount the cause bar?
So I mean, for the reasons I was saying, I think we look at the cause bar, Johnson was not decided and cert on this particular question wasn't granted until after the opening brief was filed. Reed says you have cause for failing to raise an argument when.
It's obviously not so novel anymore. And there's no external, there has to be an objective factor external to the defense that impeded efforts to raise the issue. So how do you meet that standard?
So that's James and Sykes. And that is, so the Reed decision set out two ways in which, or three, in fact, ways in which something is considered novel. One is when there's a Supreme Court decision saying, you can't raise this particular argument. Another is when there is a near universal opinion in the lower courts about the proper way for this to come out. And if you look at, I believe it's the Fourth Circuit's decision in McKinney, the court, in addition to noting that Johnson, had overturned prior precedent on the residual clause, it also noted that no one was raising the argument that the court could find anywhere that the 924C residual clause in particular was unconstitutionally void for vagueness. So I'm happy to return to another.
Now, how about on the point you started with?
Yes.
Unless there's further questions on the point you started with. So the government makes the argument on the subject of procedural default that actually that issue, the use of the text on against another person, against the proper, against what's
so it's one's own property as opposed to the property of another.
The property of another, right?
Yes.
Exactly. That hadn't been flagged early enough.
So I think the way we think about waiver is about claims rather than particular reasons, and you're at liberty on appeal to raise an additional reason for your overarching claim. I think it's clear if you look at the certificate of appealability issued here, it says, and I'm slightly paraphrasing, that the 1363's enhanced offense is not a 924C crime of violence, and this is just an additional reason for that. And I'd also note, though I don't think this is necessary for the court to focus on, that it does come up in some of the briefing below, particularly in sort of most notably in the reply and reconsideration. There's a discussion of how this offense can be committed by putting one's own life at risk. And in particular, it talks about how the word any is a broad term and cites a Supreme Court proposition, or excuse me, a Supreme Court opinion for that proposition, which is the same Supreme Court opinion we cite in our brief here. And I'd also note, there's a whole discussion about whether there's a realistic probability of that happening. And it is fleshed out. And I don't think, the briefing below is excellent and very, very detailed. And I don't think the fact that this is sort of among the least fleshed out points should be held against us because we did such a good job on everything else.
Can you act maliciously towards yourself?
I think you can. And I think you can, or at least you can.
Willfully and maliciously.
Yes.
Towards yourself.
So I think if one were to commit suicide in order to have your family collect insurance money, that would be a malicious action. In some sense, it's malicious against the insurance company, but you're not using force against them. You're using force against yourself. Or if you were to
you're going after the insurance. You're affecting the insurance company's property, not your own. What I'm talking about is if the point here is that you've damaged your own body or your own property is your sort of one of the arguments here. I just willfully and maliciously would seem to me to override any argument that you have, because it just, maybe you can conceive of it, but it seems a very unnatural way of thinking of those two words as allowing damage to yourself. You scrape your hand in the process of committing the crime, that's really what Congress was concerned about.
So I think, I think we win. So I don't want to not engage with Your Honor's point about persons, but I think we win even if you think, well, you could maliciously do it as to property, but not as to persons.
Well, either one though. I'm just wondering if willfully and maliciously don't foreclose a reading or don't naturally foreclose a reading that this applies to the defendant's either own body or injury to the own self or to its own property, the perpetrator's own property.
I don't think so, because I think you can maliciously injure your own property for some of the reasons I've stated, collecting insurance money. And I understand Your Honor's point that
different from willful and intentional. What makes it malicious when you do it to yourself?
because you're doing it sort of for untoward ends.
Well, I mean, it's not untoward in that person's, I'm just not sure. It doesn't, normally we think of malice as something targeted at somebody else. That's normally how it's used. Well, are there cases where malice, maliciously, that word has been used in criminal provisions to refer to include actions targeted at oneself, the perpetrator targeting oneself?
My recollection is it does, but I candidly don't have a specific case for you right now.
Can I just ask why does it, I think I'm missing something. Why does it matter if it's willfully and maliciously directed at oneself? Because I thought what we're talking about is 1363.
Mm-hmm.
And 1363 only deals with property. It could be your own property. I totally get that, but
yeah. Well,
why do you have a suicide hypothetical as opposed to suicide against your own property? If 13th.
So I was just attempting to engage with Judge Millett's question about a person. And so that's why I was using that as an example. But I agree that this is a statute targeted at property and one can commit malicious actions.
924C covers persons. Obviously, it covers persons first.
Yes.
But 1363 itself, unless I'm missing something, that covers property. So the question, there's still a question whether you can maliciously and willfully destroy your own property.
Yes.
As opposed to somebody else's. It does seem more natural to talk about willfully destroying somebody else's property as opposed to your own property. But does the question about willful and malicious destruction of yourself actually, is that?
So I think Your Honor is absolutely right that the court doesn't need to decide whether it's about maliciousness as to yourself, because this is a statute targeted at property and one can take malicious
The enhancement
actions.
includes both bodies and property.
Yes, but
And I am assuming by my question that your mens rea, there's at least arguments in the case that it carries through. That might not be correct, but even if we assume it carries through.
so I don't think if we are, I'm assuming that we agree, as is my position, that you can commit this action by using force against your own property, but you can't do it by putting your own life at risk. I still think that's not a 924C crime of violence, even if we're in a divisibility world, because the 924C crime of violence definition requires it to be force against the property of another. And as to the life at risk element, there's a Borden problem. You don't need to have force targeted at another person. We in the government agree that this is essentially a strict liability as to that point. So I don't think you get to this being a crime of violence simply by the person piece.
You read the life of any person part to be life of any other person, but you think the property part.
So to be clear, I don't. I'm just trying to engage with, I think, what I had thought you were getting at, which is that we can resolve this just on the property issue. And I could be wrong about whether it can be life of another person for Judge Millett's maliciously point. And to be very clear, I don't think that's right. I think you can maliciously put your own life at risk by injuring your own property.
Injuring your own, I see.
I get,
destroy your own property in a way that the shrapnel from the property could put your own life at risk.
Yeah.
And you think the statute actually covers
yeah,
life of any person being you. I mean, it could be read to mean that the property could be your own property, but the life of any person means somebody else.
right. And I'm saying we win no matter what. And I apologize if my answer on that wasn't clear. And to your point, maliciousness is, I don't think the malicious mens rea runs through the whole statute. It just goes to the property. It doesn't go to the life of another.
Okay.
And that's why there's a Borden problem.
Can I just ask you unless there's further, I don't want to stop a line of questioning on this, on the text of, so you got a lot of hypotheticals about how, you can kind of trivially injure a little bit of property and how can that possibly be a crime of violence? So just on the words of 924C, suppose that it doesn't say, for purposes of this subsection, the term crime of violence, and suppose 924C speaks just in terms of predicate crime as opposed to crime of violence. I'm just trying to take the word violence out of it.
Mm-hmm.
Then what is your argument on the text that if it just said, for purpose of this subsection, the term predicate crime means an offense that is a felony and has as an element, and we'll assume it's an element, the attempted use or threatened use of physical force against the property of another. Why isn't 1363, then put aside your of another, why isn't it all about use of physical force against property?
I don't want to resist your honors hypothetical, but I think the Supreme Court has told us we can't take the word violence out of the statute.
I'm just trying to figure out how much work that does. So
Yes.
if we didn't have, you still have your argument.
Yeah.
On that it does say violence. Of course it does. I'm just trying to figure out how much work has to be done by that word, given the rest of it. If it just says predicate crime, and predicate crime has as an element the use, attempted use, or threatened use of physical force against the property. Why then does do you agree that 1363 then would be a predicate crime?
I think it would be we'd have a much harder argument.
Okay.
But
So then if it's really all about the word violence, then I completely understand your point, and I know that the Supreme Court, and I totally get the Supreme Court's decisions that say you have to construe the words in light of the word violent, which makes a lot of sense with respect to persons. What is the construction, as opposed to just the difficult hypos? What is the construction of the words that you think works when you don't disagree that property offenses can't count as crimes of violence?
No. Not under 924C, I don't disagree.
Right. So, and under 18 USC 16, I mean, it's all over the US code that crimes of violence include crimes against property. And then what is how do we construe 3A vis-a-vis property in a way that works?
I'm sorry. I think I've lost that. I think I've lost what your question
we have
is.
to construe the words has as an element the use, attempted use, or threatened use of physical force against the property of another. Mm-hmm. What is your interpretation of those words that would fence out 1363?
I think my interpretation is that the phrase physical force requires violent force because that's what the Supreme Court has taught us in Curtis Johnson. I also think it's notable that even when the Supreme Court is interpreting other aspects of this definition, it is returning to the idea that we're defining a crime of violence. That's the Supreme Court's decision in Leocal and Borden in particular. And if you read Leocal, it specifically says we cannot forget that we're interpreting the term crime of violence.
But then what is the interpretation though? Because why doesn't 1363 count? If it's violent, I take your point, it's violent force. But
well, so I mean, I just don't think 1363 criminalizes violent force because it can be committed by acts of nonviolent force, such as actions like graffiti and the 10th Circuit.
So what would the statute have to say? The underlying statute would have to say violent force. What's an example of a property offense that qualifies?
So I think arson, when you define it as property of another, would qualify.
And why is that?
Because because actions like burning or exploding, which is often how arson statutes are written, are violent force. That offense just can't be committed by actions like petty vandalism, actions like graffiti.
So it's the quantum and kind of force that's used against property per the underlying predicate offense.
Yes.
Has to be cognizable as something that we would normally think of as violent.
Correct. I think that's right. And I think it's also notable that part of what the Supreme Court has taught us when we're thinking about this is whether the definition of force that we're considering is force associated with a misdemeanor at common law or a felony at common law. And the definition that the district court was looking at here and that the government is advocating is associated with a misdemeanor at common law, which is malicious mischief. And so I think for the reasons in Curtis Johnson, it would be inappropriate to adopt a sort of just pure injury definition as to property under the circumstances here.
Why is something like graffiti and spray paint not, why is that not encompassed, right? So, the Supreme Court says that, with respect to people, even conduct that leads to relatively minor injuries, can count, like cuts or bruises. Why isn't graffiti more like that? I know it sounds sort of plausible, like, well, graffiti is just not a crime of violence. And throughout the briefing, there's, a lot of sort of claims that crimes against property just don't really count. But if you analogize it to the crimes against persons, why isn't something like spray painting?
So I just don't think it's appropriate to analogize or to take the definition that the Supreme Court set out in Curtis Johnson and apply it to property. And this,
But why? But why? Why would it be different? Shouldn't there be consistent usage in the statute? There's a parallel structure between property and persons. And so relatively minor injury to persons can count. And maybe you just don't think property crimes are, obviously crimes against property are different than crimes against persons, but.
So I think I'm absolutely relying on the fundamental intuition that crimes against property and crimes against persons are different. I think the principle of consistent usage doesn't apply here for sort of two reasons. One, because that's how the Supreme Court has been interpreting it as not using consistent usage. And because I think there are intuitive reasons to think that makes sense. First, Curtis Johnson adopts one definition of force against persons in the assaultive context. That's pain or injury. And in Stokeling, the Supreme Court adopts a different definition, which is overcoming the will of another. And that's in the robbery context. And I think that it stands to reason that the property context would be another instance in which we'd have a different sort of underlying definition of how we're thinking about physical force when we're talking about property crimes. And I just think the definitions the Supreme Court has adopted for force against persons don't map well onto property. You look at the definition in Stokeling, which is overcoming someone's will. It just doesn't make sense in a property context. A wall doesn't have free will. And similarly, we're talking as though we're using the Curtis Johnson definition consistently here, but
we be an analogy with property. You have to maybe overcome, say, a fence or, like a dog that is like in the yard or, whatever it is. Like there might be different kinds of ways of protecting property. The Supreme Court suggests that even like minor resistance from a person can count, and there could be similar analogies with property. You are, breaching private property when you go and you spray paint on a wall.
So I don't think that's right. And I also resist the idea. I think the Supreme Court
why isn't it right?
I think the Supreme Court has sort of been all over the map, quite frankly, about what is enough force against a person. And it has said, it said this pain and injury definition in Curtis Johnson, but if you look at the Supreme Court's decision in Castleman, it actually suggests that's a misdemeanor domestic violence case. And the court suggests that actions like pinching or shoving or slapping might not be violent force. They were in the misdemeanor domestic violence context, but they weren't necessarily in just a regular crime of violence or violent felony context. And then in Stokeling, that sort of reference goes away. And then when you read Borden, it's citing that part of Castleman again. So I actually don't think the Supreme Court is really clear on, and it may be that minor force is not enough. I just am not sure we've had that case yet.
Was it a lack of clarity, or is it that, so humans, you can both have the force exercised by the perpetrator, but they also look at the impact of the force on the person. I mean, they're just looking at force from two sides. They're not leaving it just in what the perpetrator does, but how, is what Delegati is what the impact is on the person. And it's harder to do that with property, right? If you leave someone locked out in the cold, or you don't give them water, and they suffer physical harm from it, that can be violence under Delegati. But if you don't water the lawn, or leave a house out in the snow, we don't consider that violence against the property. So I don't know that it's inconsistency. It's just looking at it from two angles for people in a way that you don't do necessarily for property.
So I think the court is right that in Delgatti is not illuminating for property Delgatti doesn't map well onto the property context for the reasons that you've just stated.
But what I'm wondering is, I mean, this all seems, Curtis Johnson says it's, causing pain or injury is what we mean by physical force, violent force. At the time, the second half of 1363, the enhancement provision was enacted. Black's Law Dictionary actually had a definition of injury to property, which was material impairment or destruction. Now, if we think that's what injury to property meant at that time, at least, that it actually was an understood term that was used as material impairment. So if we read material impairment, or we read injury in 1363 to mean as to property, material impairment, and that's what is the parallel to physical injury for people. How could someone commit an act that causes material impairment to property without using the type of physical force that would be covered by the 924C?
Because I don't think, even assuming that 1363 uses that material impairment definition from Black's, I don't think that definition from Black's is the definition that makes sense in the 924C context, because we're not just talking, we're talking about a violent felony. We're talking about a category of felonies that are
property. What makes something, what the Supreme Court uses pain or injury as to 924C as well, as to the violent crime of violence language. That's how we say what we mean by physical force, causes pain or injury. The definition of crime of violence, physical force means causes pain or injury, thinking about people at that point. And so we have to figure out what is the equivalent of pain or injury to property. And if there is at least some evidence of an understanding at the time that material impairment would be an injury to property, as opposed to brushing up against the side of a building, or perhaps, flicking a piece of paint off the side of a building. If it's material impairment, and it takes some force, some higher level of force to cause material impairment, rather than minor intrusions of the same equivalent to the touch on somebody, on a human body, then it seems to me that you don't have a problem then of anything under 1363's enhancement clause,
so
including crimes that would not be crimes inflicting pain or injury on property.
So I think that leads to a quite frankly, pretty bizarre outcome. There is not at common law the government suggests like a trespass to property is analogous to the offensive touching at issue in Curtis Johnson. But there is no common law crime on my understanding of just a trespass to like a chattel. That might be a tort if you intend to convert it, but there is no common law crime of property. And so if I just don't think it makes sense that Congress would have adopted a definition of force against property to define a violent felony that included just essentially all property crimes, but included a huge number or excluded a huge
It's
number.
not all, that's the whole point. If it's got to be material, that we'll have to decide how that's defined. But if it's got to be material, if there's some, quantum of force upon the property that has to be exercised, it doesn't actually have to, but could have caused material impairment. Why is that not equivalent to what has been recognized as the types of force that are against people that are sufficient to constitute crimes of violence?
I just don't think there is a crime against property involving non-material impairment, like a common law crime against property involving force against property, but non-material impairment of force against property. I think you're defining the definition of violent physical.
By a common law definition of a crime against property. We're talking here about what Congress has done in these statutes and what it meant to capture. And if the whole point is that, surely it didn't mean to capture every injury to property. I mean, if I come in and flick a piece of paint off somebody's house, they'll have a common law claim against me for whatever the damages are it costs to repaint that inch of the wall. But that doesn't say that would be a material impairment of the type that Congress could think of as constituting physical force against property, a crime of violence against property. I mean, crime of violence, your whole argument is crime of violence has to be something more than everything that is an intrusion on that property or everything that affects or damages that property in some minor way. And so if that's right, then we have to say, well, okay, it has to be a non-minor way, which would be a material impairment. And if it's a material impairment, it's hard to figure out how that's caused without the type of physical force that could fit within 924C's understanding and sort of map, at least it's a parallel onto what the Supreme Court has done thus far.
So I understand your Honor's resistance to my invocation of common law, but that's not because I think that makes sense. I do, but I'm bringing it up because that's how the Supreme Court has talked about how we're thinking about the definition of force. It's rejecting the common law definition for like misdemeanor assaultive force and adopting the common law definition for felony robbery. And so I think here it doesn't make sense for the court to adopt a definition of violent force against property that is one that is associated with a misdemeanor common law and say, oh, but don't worry, we're excluding non-material injuries to property when that is like a null set. I mean, it's just not a crime.
But I thought if the underlying crime is 1363, so we already know that we already know what the predicate crime is. It's not common law trespass or common law injury to property, whatever that is. It's 1363, and 1363 speaks in terms of willfully and maliciously destroying or injuring. So it seems like just leave alone injury for just a second.
Mm-hmm.
Well, willfully and maliciously destroying property seems like that's pretty significant. You're destroying property. And if you read injury in light of willfully and maliciously destroying or injuring property, then that seems like it would have to be a pretty substantial injury. It can't be a trifle. And if that's true, then that's just what 1363 bars. And if 1363 bars willfully and maliciously destroying or injuring in a way that's commensurate with willfully and maliciously destroying, then injury would be seen to be, seriously impairing, seriously harming, something like that on the scale of destroying. And if that's true, then whatever you think about common law, that's just what we read. And that's the crime that we ask whether it counts as a crime of violence, meaning has as an element the use of physical force against the property and put aside of another. We'd be talking about willfully and maliciously destroying or injuring, meaning injuring in a way that's commensurate with destroying and acting willfully and maliciously, which means a pretty serious injury.
So I think 924C requires a pretty serious injury, or force that could result in, by your honor's terms, a pretty serious injury. But I don't think, I think the injury courts have read 1363 to allow for like cosmetic, somewhat trifling injuries. I mean, actions like graffiti.
Has this court read it that way yet?
I know this court hasn't, but
We're asking the question whether, and, you know, given there was a dictionary definition at the very time this supplementation thing was enacted, and the whole 1363 was reorganized and arson moved out. So it's sort of this operative provision that required material impairment. Then why wouldn't we read that to be what injures means here? And if we do, we have, as Chief Judge Srinivasan said better than me, we have the element. And why wouldn't that element map onto the physical force required in 924C?
So I think
You have to decide what injures means in this statute to understand what that element is. And if injures means any trifle, then that's, you know, I understand your argument on that front. But if that's not what the element means, or that's not the best understanding of what the element means, then it's a very different analysis as to what happens under 924C.
Sure, but I think we understand what the element, I think both parties agree what the element means, which is it can include things like, I mean, material injury to me is not a substantial injury. Just any materiality is like, can be a very, very low standard, and as the cases.
It's material impairment in Black's Law Dictionary, material impairment. So that means, you know, impairing function, purpose, use of that piece of property. You know, and quite frankly, if you spray paint black all over a windshield so a car can't be driven, that might be material impairment. We don't have to decide that in this case, but you're really starting to look at not just, like the Supreme Court does, you look not just at the force that is done, but what is the consequence for the target of that force? And if material impairment, that seems like it's very similar to what we look at in the physical force upon a person area, where is it really having a force upon their body that affects their freedom of movement or their health or well-being. And so it just seems to me deciding what injures means. And if you want to, I take it your reading is injures means sidewalk chalk on the sidewalk.
Yes, I think it could mean that, but I
That
think.
doesn't seem contextual next to destroys.
I mean, just injures is clearly intended to capture something less than destroys.
Right.
And I think so it captures things like actions like graffiti. I think, I guess I resist your materially impairs definition, or to the extent it applies, it covers actions like nonviolent force.
Well, I mean, I think, you know, you don't destroy, but you shoot out all the windows in a house. That would be injuring. And that would be materially impairing it.
Yeah, but it wouldn't be the least culpable conduct
I
criminalized
understand.
under the statute.
I understand. And so we're really trying to figure out what were they capturing with injures here. It just seems to me that's what the heart of this case is what does injures in 1363 mean? And is there what rule is it that you rely on to say that we have to understand injures to be anything that affects, touches, harms, damages property in any way, or maybe doesn't even damage? What is your definition of injures here?
So I think my definition of injures here is any form of damage.
Congress uses damages in other statutes. Some property ones are injures and some are damages. And so it may actually not be damages.
So I guess when I say damage, I do mean physical damage as opposed to like sort of damages in a more abstract, like monetary.
No. There are other statutes that also talk about damage to property and punish that. All right. So it seems to me that there's injures, and at least again, when used in conjunction with destroys, as the Chief Judge was pointing out, when you read it in context here, and add in willfully and maliciously, that it seems like we don't have to, I just don't understand I understand that's your reading of injures, but what statutory construction rule compels us either compels us or shows that that's a better reading of injures in 1363 than the material impairment one.
So I guess I think it's, I mean, Your Honor has offered one definition from one dictionary, which I understand, but it's not clear to me that that is, if you look at every dictionary, that's the definition that you're going to get. And just quite frankly, I think, we can.
I'm asking what your rule is for definition of injures. That would be, we have to construe the statute. It seems to me that's the starting point of yours. And so we can start with the term and then we'll look at context. But if we start with the term, yours is, because you can't, if you just look at injures, you're going to get a lot of the same problem we have already, which is looking at injury to people definitions. And that's why I thought it was interesting. There was actually injury to a building definition. And so what is you're just doing a plain meaning of injures?
I think it's a plain meaning of injures. And I also think it's notable, a lot of statutes have like monetary thresholds and the like. And I think the absence of a monetary threshold is a sign that this is intended to cover minor actions.
But, well, you're dealing with a lot of property too that doesn't sort of have fair market values when it's government property. So I'm not sure, there may be a reason for not having monetary thresholds here as well. But I think plain meaning seems a little hard for injures because for the very reason I said, which is its plain meaning is understood by people in terms of humans impact and not, at least nowadays, maybe it wasn't historically. We don't often talk of injuring someone's property. We talk about harming it, impairing it, destroying it, but injury to property is not something that we use that commonly. And if we do, I'm not sure that there is a common understood plain meaning of what it is. That's why at least I am in this box of trying to figure out what it means here.
Yeah. I mean, I guess I have the instinct that injuries to property can be very minor. I mean, we had a recent case where in the district court where someone was not under this statute, but someone was finger painting in washable paint on the exterior of a like Degas Tiny Dancer in the National Gallery. And the government argued that that was sufficient, just the like washable paint.
But I'm assuming you resist that. I mean, if you have a client who urinates on public property, I'm assuming that you're going to make the argument that 1363 doesn't cover that because it didn't injure the property.
Sure, but I suspect I lose, I think.
Okay, but I take it the part of the reason it just seems to me is that when you have destroys juxtaposed with injures juxtaposed with destroys, I've got the directionality right. What destroys connotes is there's some permanence to it. And so if you think about injury in the context of destroys, it seems like the kind of injury that has some lasting dimension. Of course, there's going to be line drawing issues. I don't deny that. But
so I think exactly the opposite, in fact. The fact that destroys is about permanence suggests injury might, in fact, be about impermanence.
I mean, you wouldn't need the word destroy if injury covers everything anyway. So I think, to me, the more natural way to try to think about what injury means is not to just assume away destroys and think, oh, you can physically destroy everything and just render it a non-piece of property forever. Or if you actually touch it, that also counts. That's kind of an odd way to think about what a statute covers. So it seems to me, because why would you talk about permanently destroying it if just touching it would be enough? So it seems to me the way to think about injuries in the context of what destroys means and what that connotes is some kind of lasting damage. And so if there'd be a question about graffiti, I mean, it takes something to graffiti is not nothing. It actually does impair property in a way. It takes something to remove it. There's other things you can do that probably don't do any kind of lasting damage at all. But so there would be line drawing questions, but it seems to me that part of the question would be injury means something that has some lasting quality to it as a substantiality dimension. And then that's what we would read into 924C. I mean, you could still have an argument that that covers too much, but it just seems to me it's tougher if we think about injury through that lens, through the lens of destruction.
So I think I mean, I guess I resist the implications that you're taking from the word destroys. And in particular, I think any of the definitions being batted around about injures would still mean that destroys isn't doing work, because the definition of injury you're adopting would cover destruction. I don't see a way of reading injury to exclude destruction.
Would we I mean, we're not construing just any old statute here. It's a criminal statute.
Certainly.
And so your sort of plain text, well, they must have meant to capture everything. Makes me wonder, is that really the best rule when you're reading? If you've got at least a variety of dictionary definitions, if you've got contextual indicia, is that really how we're supposed to read? I understand why you want to do it for purposes of the 924C categorical rule. But if we set that whole paradigm aside and we just look at 1363 itself, is it normally the rule that we read words in criminal statutes to reach as far as humanly conceivable?
No, I don't think so. But I think in some sense, Your Honor is getting at sort of, if there are a bunch of definitions and it's ambiguous, we use the rule of lenity, which I wish was, quite frankly, the way I feel like courts are applying the law. But
well, you'd want that in some of your other statutes, but when we get to categorical rule, then I mean, it's sort of both sides are cross purposes in this area. I get it. It's not just you. But as I said, the first thing you have to do is interpret this statute. And so it just seems to me that our first instinct wouldn't be to go for it means any possible unfortunate touching or malicious touching of property. And I'm not even sure we'd look at common law when you're talking about, things within special maritime and territorial jurisdiction of the U.S. government.
yeah, and I apologize. To the extent I was unclear when I was talking about the common law, what I really meant was what we're interpreting 924C, the Supreme Court has taught us. That's part of how we're supposed to understand the physical force definition. Not that I was sort of arguing that for 1363, and I'm sorry.
And the question is where you start, but if we're starting in 1363, then.
Sure, but I think that's why I think even if we accept your material impairment definition, I think that definition.
Mine, to be sure, it's Mr. Black's.
Fair enough. I apologize. If we were to accept Black's definition as the definition here, my point is that I still prevail because 924C picks a different definition. And I do think there's some agreement here, though perhaps I'm mistaken.
924C require. Sorry, go ahead.
I think I was going to say something.
924C says we look at sort of we don't look at the lowest common denominator of words in the abstract. We look at sort of the lowest common denominator of what that element covers, what it means, how it's defined. And so if it's defined in 1363, if we read it as having this meaning of requiring material impairment, significant damage, whichever collection of adjectives you want to use, if we read it as something much higher than, a chip in the wall, then that's what the 924C test goes on to. And then you have to ask the question of whether, can one take whatever physical force it takes to accomplish material impairment of property? Can that be, in any sort of realistic sense, a level of force that is not the physical force under 924C?
So I think that's right. I think a small, and my point is that 924C requires more. But a small sort of note is you referenced like realistic, and which to me calls to mind the realistic probability test. And just for avoidance of doubt, I don't think that applies here.
No, I was talking about the Supreme Court has said, look, we're not going to sit here and engage in first year law school coming up with any sort of inane hypothetical we can think of on this. We sort of look at what does that language capture? And if someone could, after weeks of study, come up with a single hypothetical that might sort of push the envelope on crime of violence, that won't be enough. You have to have some sort of, that's what I meant by that.
Okay. I think
I don't know what that said is either, as opposed to hypotheticals we do get to use, but that's what they've said.
I one additional point on that, and then I want to return to quickly what I was saying before. I think the realistic probability test, which sometimes is like we don't get to engage in hypotheticals, the Supreme Court has said doesn't apply in the context of a federal statute, because that test came about when we were worried about federalism concerns and sort of getting ahead of what state courts were doing. And in Taylor's recent decision, the court said, no, it doesn't apply in a federal context. We're federal courts. We interpret federal statutes. But putting that aside, I sort of want to return to my basic point very quickly, because I do think your question suggested that you would think, you agree that the graffiti example meets Judge Black's definition. And if that's...
Depends on how much graffiti. You think up and make a little mark and a smudge in a corner, that could be very different from blacking out all the windows on a police car so it can't be driven when a call for help comes in. Or hate graffiti or things like that could be different than, I don't know.
I think, you know, we have
to think of all graffiti as, does your position have to be all graffiti categorically is out or is in?
I think
all
graffiti or like
is not physical force on property.
No, I think all graffiti is a violation of 1363, and because there are versions of.
I don't know if stepping up to a building and doing this with a spray can would be willfully and maliciously destroying or injuring the structure. I'm not sure that
real or person. I think that's how the statute is being used, and how like courts are agreeing that people who engage in graffiti, whether it's a dot or whether it's a whole, graffiti tag or, words of protest. I mean, people are getting absolutely convicted under the statute for those types of actions.
But not in this circuit yet. No. You continue to tell me, the Supreme Court hasn't said that.
Yes.
If we haven't yet spoken to it, it may well be that courts, this is not easy, right? This is hard. This is a challenge. And it's understandable how reasonable minds could have gotten. And as you said, the Supreme Court's own test is clarifying, evolving as it goes. And so everyone's doing their level best here, but we're trying now to propose something that keeps 1363 within some sort of bounds, makes us narrower than everything, than every possible touch upon property, not willful and malicious touch upon property. And I guess I still haven't heard a rule of construction that compels us to do otherwise, if one were to conclude that there's other textual and structural indicia here that weigh against reading it so broadly. And since we're sitting here in the middle of territorial jurisdiction of the United States, it seems important for us to be very careful in how we say what injures means here.
So I take your Honor's point. I think I've given my thoughts on it. Are there any additional questions? Do we want to talk about divisibility or Borden or anything? Or I'm happy to.
Unless we'll give you a little time for rebuttal.
Thank you, Your Honor.
Sure. The government now. Mr. Cahill.
Yes, Your Honor. May it please the court, Timothy Cahill for the United States. Appellants claim that a 1363 violation is not a crime of violence. It's both procedurally barred and meritless. And as appellants attempted to do, I would like to begin with what we would view as the simplest way to resolve this claim, which is that it is procedurally barred.
What has been your procedural bar argument? As far as I can tell from your briefs, you've never once said anything about dependency of Johnson while this case was on appeal.
I don't think we specifically pointed that out, Your Honor. I think it certainly supports it. I don't think we don't view that as a necessary fact here, but it certainly supports it.
Your entire argument for procedural default was that Justice Scalia had dissented in some decisions, and therefore the defendant could have made some arguments in the trial court at sentencing and at the time of pleading guilty.
Certainly, the fact that Justice Scalia made those dissents was more evidence that this was not a claim that was novel. These were claims that were being litigated, that were being presented.
On that score. So let's, as far as I can tell, you've never argued anything about Johnson's pendency while this case was on direct appeal. Not once. I know you used the word direct appeal in the heading of your brief and then in one sentence, but in terms of what should have been done, it was all about what could have been done in the district court. Not while it was on direct appeal, but what could have been done in the district court. And on that, at the time the case was originally before the district court, there was Supreme Court precedent that just flatly ruled out the claim. And I'm not aware that procedural default principles require one to preserve a claim that's flatly foreclosed by Supreme Court precedent.
So I'd respond on two levels, Your Honor. So first, as Your Honor suggested, our position here is that it would. And I point to we believe that the Vargas Soto decision in the Fifth Circuit that held exactly that in the context of a Johnson Davis claim,
so
it was correctly decided.
So that's the way procedural default works, is that even a defendant is expected to flag everything that's flatly foreclosed by Supreme Court precedent just on the chance that the Supreme Court might in the intervening period grant cert and reverse its own and see the stare decisis criteria satisfied. It happened to happen here. But, and then is that really the way procedural default works?
I mean, certainly in the context of the Supreme Court in Boosley and Murray saying that futility isn't cause, and Murray specifically contemplates the idea that you can, if you want to have an attempt to convince a court to change its ruling, to seek a change in the law, you need to properly
None of
present
those
and
involve a
preserve it.
situation in which a claim was foreclosed by precedent.
Or foreclosed by Supreme Court precedent, I would
Or even circuit precedent. I don't think Boosley or any of those, they didn't involve a claim that had to be raised, even though, I mean, everybody, you can do the thing where you assert a claim before our court and you put it in a footnote and you say, I know it's foreclosed by precedent, but I'm just doing it because I want to preserve it for on bank review. I mean, I understand, but does procedural default in the criminal context really mean that criminal defendants have to flag claims before a court, even though that claim is foreclosed by precedent? It does.
Again, Your Honor, and again, I would point to, I think, the Vargas Soto decision we find persuasive. It has an extended discussion of this. I understand if this court certainly is entitled to disagree. That's not binding authority here.
What about this circuit?
This circuit,
Bound by decisions of this court? We're bound by DC Circuit prior case.
certainly, Your Honor, this
No
panel is,
one,
yes.
the government, the judge, or the appellant could reasonably have anticipated Johnson. We've said that.
Yes, Your Honor, and I think
And you're saying
clear point
in a procedural default context, we said that.
I think the relevance,
So
or
you're saying-
to characterize our argument, I think maybe more clearly, is that the ability to anticipate the specific outcome of a Supreme Court case isn't the test. The test is whether the tools to construct the claim were available. So this court, of course, would not have to deviate and could not deviate from something a prior panel has said. We don't view that as precluding the application of a procedural bar here.
If we've said no one could have reasonably foreseen this, how could we say that at the one time and at the other time say, but they should have reasonably foreseen it and preserved it?
The fact that they couldn't have foreseen the outcome of that case doesn't mean that the tools weren't available.
No one saw this coming. No one saw, based on justice, we could all have read Justice Scalia's dissents 100 times a day and still not said there is a colorable claim to present to the district courts or the courts of appeals that the residual clause is unconstitutional, at least of ACCA, or even more relevant here of 924C. I mean, you'd have to have a whole nother leap here. So it would have been unreasonable for them to have raised a challenge to the residual clause of 924C here, and said you only have to look at the elements clause. And so let's talk, I mean, you have to go through so many loops here. And so then spend a whole brief, as they've had to do here, trying to argue about what the elements clause means. That's your view of what should have happened here.
Certainly, our view is that to the extent appellant believed that this was this was legally a meritorious claim, that in order to
What is this?
a claim that the residual clause is void for vagueness. That had to have been raised in order to be preserved. I would also add, I understand that we did
I
not.
thought your argument was, the argument they're making now is that, okay, but if you can't do that, it's to Srinivasan's point, if you're the defense attorney, you can't just say, we think it's unconstitutional. Supreme Court does not. The circuit does not. But we think it's unconstitutional. You can't stop there because then you would have to go. So that means we have to look at the elements clause. And then you'd have to have a whole brief section, which, as you know from this case, could be quite lengthy on what happens with the elements clause here. And, unless we're going to allow in criminal cases 200-page briefs, it's just untenable. Say that when we say no one could have reasonably anticipated this, we nonetheless are going to sanction defendants for not reasonably anticipating it.
So I understand, Your Honor. I don't think it would require 200 words. I think it is not uncommon to see litigants preserve claims if they intend to seek further review on them in much more concise fashion. And that wasn't done here. I would also add, though.
Wait. You can't stop there. I get we drop a footnote or we have a one-line header preserving this for further review, but that would have been no help to them. Then they would have had to devote their time to arguing about the elements clause.
Well, I also don't think it's uncommon or inappropriate for parties to make arguments in the alternative, especially if they think that one of the arguments is less likely to succeed, but that doesn't absolve them of a requirement to properly preserve it. But
my point is how much this elements clause discussion cannot be done briefly.
Certainly not, Your Honor. I wouldn't suggest it would.
So then there would have been nothing left in the brief for other issues.
In any particular case, Your Honor, I mean, how much time and energy is devoted to a particular claim, I think would come at the litigant's discretion, but I don't see that as having direct bearing on the procedural default.
I think the point, you're right, it's come at the discretion. I think the point is, if you exercise your discretion to say, I'm going to make a claim that's foreclosed by current Supreme Court precedent, and then, as Judge Millett says, actually, you don't automatically win. In this case, you got to do more than just say that Johnson has yet to come about, and I think actually the residual clause is unconstitutionally vague. And then the consequence of that is this and this and this and this, and it just takes a while to spin that out. It just seems like an awful lot to expect defendants to do. Now, it's different when it's on direct appeal. When it's on direct appeal, Johnson comes down, and then there's an argument, or the question actually is at least put to the litigants that this is now an open issue. That at least opens up some different avenues, because at that point there is binding Supreme Court precedent, but the Supreme Court itself has signaled that precedent might be overruled. It's just you haven't, as far as I could tell, you've never made an argument about that. You've never said the significant moment here is what happened while it was on direct appeal.
I don't believe we did specifically point that out, Your Honor. I would submit, for what it's worth, I don't think that would preclude the court from taking notice of something that clearly is a matter of judicial record.
Have you forfeited that procedural bar?
Certainly not, Your Honor, given that we raised the procedural bar pretty thoroughly. But again, I think our argument on this is what it is. We could choose to do it. I'm just saying, and a procedural bar is not jurisdictional, so we don't have to do it. I don't think you think that, right? I mean, would it be? I mean, it would. I don't think you could say in a brief, because you did use the word direct appeal. I'll give you that. It says direct appeal, but then it only talks about what happened in the district court. And so I don't think. Suppose you had written a brief that said to us, I think you'll see that if you do the work, this was procedural defaulted on direct appeal. I don't think that would have preserved what happened on direct appeal, right? For us to go and find out when Johnson was decided and then all that, you wouldn't take the position. I'm not sure, Your Honor, if not written using that language. I don't want to venture.
And you never
here.
would. And I'm just saying, but that's kind of the position we're in with what you briefed, because you did nod to direct appeal, but there was no explanation about any salient date on direct appeal. I acknowledge that was not in our brief, Your Honor. Again, I do think it's a matter of judicial record. It was not in our brief. I do, of course, want to also address the merits. We maintain procedural bar applies, and that's the simplest way through. Of course, we also believe the claim is meritless. And there are a number of issues that were discussed, especially in the context of the notion of how much force would be required or violent force with respect to this claim that I would like to address. And I wanted to start with some of the discussion about the relevance of the word violence here, and point especially to the discussion of the
term violent in Stokely. Now, of course, the Supreme Court has in Curtis Johnson and in Stokely talked about the fact that that word carries some significance, but it doesn't necessarily carry the significance that a layperson would attribute to violence when they're thinking about a violent movie or something like that. In Stokely, and the Supreme Court said and pointed out that at common law, violence and force were used interchangeably and weren't focused on specific gradations. But the key distinction was the distinction that Curtis Johnson drew, which is the difference between force that's merely offensive or unwanted and force that causes injury. And we maintain that the principle of consistent usage applies very strongly in the context here, where the Congress used the word physical force only once in the statute in the same phrase, applying without any distinction to both property and to persons. And we reject the idea that the Supreme Court has used different definitions of that phrase in Curtis Johnson and Stokely. Stokely made clear in its terms that it was an application of the Curtis Johnson definition of the force capable of causing injury. Sufficient to overcome a victim's resistance wasn't a new definition. That was the force required in the statute that was under examination in Stokely. And the Supreme Court said force sufficient to overcome a victim's resistance was violent force because it was force capable of causing physical pain or injury. It wasn't a new definition. It was a level of force. It was an example of force that qualified. They didn't say that that was the threshold. The threshold remains Curtis Johnson's definition. They applied Curtis Johnson in Stokely. It's not a different articulation. There's one articulation.
Right, so as far as I know, property does not suffer pain. So then we're doing the word injury. And coincidentally, the statute uses the word injure. And it seems to me, whatever the scope of 924C, we don't get to that until we first figure out what destroys or injures property, to be short, means under 1363. And so how does the government define injures in 1363?
So the definition we propose, and I think Judge McHugh in the Bowen dissent used this drawing language from treatises and from Black's Law Dictionary, was if it harms or damages or causes substantial impairment to the use of the property.
Impairment.
And so I know Your Honor used, I think, maybe the word material impairment. I think this was substantial impairment, but I think they're driving at the same interest, those terms that Judge McHugh seized on there. And so certainly, that is a definition that we would be satisfied and be comfortable with applying here. And to the extent that
Substantial or material impairment to the property.
but I would note that, to our view, that still covers something that, for instance, would require any sort of repair or restoration to the property. So I think it is
Any repair? So, all right. So I've got my sidewalk chalk. And I go up to in a government school on a military base and willfully and maliciously make it nice with my, not sidewalk chalk, indoor chalkboard chalk on the chalkboard. And I've done it willfully and maliciously, and it was all clean and was supposed to be writing on it. Have I injured that property by marking on it?
I think to the extent that to Your Honor's, I think Your Honor's driving at that perhaps it could be restored by erasing it.
You just said if it required, it has to be restored.
No, well, that's what I'm driving. So if that's the example of the restoration and restoring, I think that would be certainly a difficult factual case, whether or not erasing constitutes repair or restoration. I think we're cutting. I'm sorry, Your Honor.
No, yes. So you're the one who used the word restores.
It is.
On the other hand, you said substantial material impairment. Government's okay with that. Those are not the same thing. Anything that requires restoration, which could be erasure, it could be a little soap and water, rub it with your elbow. That's all restoration too. And that is not going to map onto a substantial material impairment test. So that's why I'm trying to understand which it is.
I understand Your Honor's point, and it maybe requires substantial impairment that
Substantial restoration. I don't know how many adjectives you want to use.
Perhaps. I do think, and I don't mean to evade the particulars, because I understand that has to be on the court's mind. But I also would suggest that in any definition here, there's going to be close calls. And given that the statute at issue here specifically uses the word injury to property, to the extent that this, whatever definition that this court would fashion, if it finds hypotheticals falling below that standard, then they wouldn't be violations of 1363 in the first place. Whether or not the government even agrees with that, they wouldn't qualify as violations of 1363. So as long as injury means the same thing in 1363 as it does when we're deciding what constitutes physical force in 924C, then 1363 qualifies.
I don't think that has to be at all. I mean, let's assume, I'm not saying this, but let's assume 1363 said, you know, significantly injures in a way that permanently or for a prolonged period of time disables use of that property. I've obviously added a lot of words, but they have, under my example, made clear that injury here is a great big deal and it has to be really disabling of the property. We would read that phrase about injury in there to be, could be very different from whatever it means in 924C. It wouldn't matter. What we would say is, here's what the statute means, and we can't think of a way, we can't find a least common denominator that would accomplish that level of injury to property that would not constitute violent force or physical force under 924C. 924C could be less. We don't care. We're not interpreting that statute. So I don't think we have to say injures means the same thing here or there. And I'm not sure I even know everything that it means in 924C.
And I take your Honor's point, and perhaps it'd be more precise to say, we certainly see no reason here to interpret the term differently. As it would be used in the context.
How we interpret this statute? We don't, should we interpret this statute, which I think was written long before 924C? Why should we interpret it as meaning the same thing?
In the context of what constitutes injury to property? I mean, because
When was 924C adopted?
I do not know offhand, Your Honor. I apologize.
Was it the 1940s? I think it was after that.
I agree that it was after that. I don't have the date on the top of my head.
The relevant provision we have now, I think 1948, but 1940s. So I don't see any reason to think Congress would have thought parallelism. If anything, they would have thought, and I don't think this is right because 1363 is such a specialized statute. 924C would be responding to 1363 and not the other way around, but that doesn't make any sense to me either. So I don't see any reason that we have to read this to equate with 924C. That will get sorted out maybe in case law. So I wasn't sure why you said that.
I said it, Your Honor, because again, I think when Congress is using terms like willful and malicious destruction or injury to property, and then the Supreme Court is later using those same terms and even drawing those terms from a long-standing history of common law that does go back prior to 1940, would submit that it is reasonable in that those circumstances to view those as meaning the same thing.
I think 924C itself requires willful and malicious, and it says pain or injury. So it was thinking obviously about people because buildings and property don't suffer pain. And it's not clear to me that the common law definition that they were using there, because they said pain or injury, that they were giving a definitive, tell me if I'm wrong, a definitive definition of what injury to property means, even for 924C.
So the Supreme Court, to your Honor's point, has not in Curtis Johnson or in Stokely was not in the context because it was under the context of the ACCA.
Right.
Did not have the context to look at what it means in the context of property.
Right.
But
so we don't have the Supreme Court saying.
Well, but I was pointing more to the principle of how the Supreme Court is interpreting these words and where they were looking for the interpretation of these words.
Is there a common law definition of injury to property?
I think the ones that Your Honors identified from Blacks and from the treatises that we cited are the best examples of that, and that's the definition we proposed.
Do you think that the graffiti example where somebody walks up to federal installation and just does a period on the side of the building, does that violate 1363?
With paint, I think it would. Yes.
It injures it in the manner of destruction because
it would require a level of repair to get it back to what it was. It's damaged the property.
Any level of, what about public urination?
I think it's more questionable whether that would require any repair or whether that would, but I don't know. I think that's a more difficult call, Your Honor. I'm not aware of it being prosecuted under the statute. I understand that's not the task.
I think your whole argument for you to win, you have to read something into 1363 as to what injures means that would rise to the level of having as an element physical force against the property of another that meets some relevant sense of violence.
So I understand you're, and so the proposal that we have made, I understand there needs to be some limit, and our position is that that distinction, and I know Appellant said this is an analogy the government drew. It's actually something we drew from, I think is well established. We drew from the restatement, is that in the context of property trespass, unwanted contact is not sufficient. And that is analogous in the context to people of what battery would be. The lowest form of battery can just be unwanted or offensive contact.
Right. So urination is not trespass. It's something more than trespass. And I mean, it may be also be a trespass, but it's something more than that. And then is that willfully and maliciously? And it's done, let's say it's done for protest reasons, just to make clear that it qualifies as willfully and maliciously. And it's not just for relief reasons. Willfully and maliciously destroys or injures a structure.
I think that is a more difficult call to say that it injures the property than paint.
Why is it more difficult?
Because again, I think paint would require some level of effort to restore it.
It takes soap and water. I don't want to smell that stuff.
I assume somebody does something in response to that with the property, as opposed to just lets it sit if it's witnessed.
I think someone probably would, whether it's required or not. Again, I think we're pushing up against.
But you could leave a dot on the side of the building too, and you could think no one's going to see that. And it just seems to me that it bakes in some way a notion about what is the significance of the measures that would naturally be needed to be taken in light of the incursion on the property. That just seems like a natural conception to build in when you're talking about some act that willfully or maliciously destroys or injures property. Some things just are not going to qualify as injury to property within that context, even though they definitely incursion on the property. In some way, they definitely are. But I mean, if someone comes to the side of a building and flicks it like this, and you see some dirt coming off the side of the building, you could say, hey, that's an injury to the property because there was some loose concrete there and there's a pebble that came out. I mean, is that a violation of Congress decided to criminalize that in 1363?
And I understand Your Honor's hesitance to view the statute as reaching that far. Where I would push back a little bit is the idea of very, very minor incursions being covered by physical force and being covered by violent force, because in the context, understandably in the context of people, because that's all the ACC covers, the Supreme Court made clear that something as small as grabbing or pinching could qualify, even if it's just a fleeting moment of pain is sufficient, a fleeting injury.
But they defined it not as just injury. They defined it as pain or injury. And
Well, I agree.
Pain and probably pain and fear and terror on the part of the recipient.
I mean, pain, Your Honor, is a living being's response to injury.
Right. That's
So, but I'm saying it doesn't.
Injury thing does not map onto property because you have to at least carve out the pain thing. And so then to get some.
Well, I think
I don't have property that feels pain.
I think pain is.
Unless you consider my pet's property.
Sorry, Your Honor. Leave aside the pets. I think pain is an example and evidence of injury in a person, and so it's not an example of evidence of an injury of a property. But the point remains that a fleeting and minor injury is clearly sufficient, even where.
I think what that misses is, sure, it's true that a trifling contact with the human being can cause pain in a way that would be seen as violence. But that doesn't mean that a trifling and fleeting contact against anything that doesn't even feel pain also meets the physical force requirement, because you don't have the pain part. So if you don't have the pain, I mean, if a building could say, ouch, that hurts, then I agree with you. Then you would say the fact that one's a physical structure and one's a human being, that's established by the Supreme Court case. All I'm saying is the fact that the Supreme Court case introduces pain is not something that you can just, to use a phrase, flick away, because actually that's part of the conception that makes it rise to the level of violence. Even though you could see I think the point is, even though you could see the action as something fairly fleeting, there actually is a consequence. It causes pain to a human being. You can't say that about a building. So then I don't think you can just do the rote transposition and say the same contact against a building also qualifies because the Supreme Court talked about it.
Well, it should be clear that I don't know that it's necessarily the same contact, because the Supreme Court was interested in outcomes here. So, but the same concept that even a very minor or fleeting injury
would be sufficient is what would apply.
When it causes pain.
I think it's just that it's hard to, I mean, it's just hard to, we can parse the fine details of a Supreme Court opinion for ages. They just didn't have a case before it that had to do with property. And I think everybody agrees. I mean, you agree. I think the other side agrees. This property crimes just raise a different set of considerations, and it's hard to rotely transpose what's been said. It's instructive and we have to take it into account, but it's hard to rotely transpose what has been said to the property context. And it seems to me to be entirely reasonable to look at a statute, a federal crime that involves destruction or injury of property and think that may require something more significant than a flick to the side of a building.
I understand, Your Honor. I think we read the statute more broadly. Certainly, we would welcome an opinion that.
I thought you agreed earlier that it required substantial or material. You were fine with that reading, and now you're defending the pinching the building effectively. Do you consider that substantial or material? If I go up and flick a piece of paint off the corner that no one could see? No one's even going to notice a little piece of paint off somewhere?
I was thinking I was speaking more to the ones that the hypotheticals of actually painting something on it, even if it was a very minimal.
Yeah, I'm going to make a mic. I've got a very fine paintbrush, and I'm going to put a little dot on there that no one's going to see. And I'm betting the government's not going to even spend the resources to bother painting over because it's not visible, but it's the exact same act as a bigger paintbrush. You know, to the extent it's received by the building, it's a touch. It's a fleeting touch that changes in some microscopic way the outside and appearance of that building in a way that is not adding value.
I understand, Your Honor, and if to the extent that
But when you said you would agree with substantial or material impairment reading of injury in 1363, I am not talking about 924C, in 1363, how do you define substantial and material?
So one step back, I think our position as outlined in the brief is somewhat broader than that.
Okay,
it was damage or substantial impairment or substantial impairment or use.
Wait, damage? So any old damage. Now, Congress did not use the word damage here. It used it in other statutes, damage to property is criminalized. So we cannot read this as damage.
Respectfully, Your Honor, that was I said, I was pointing the court to, it was Judge McHugh's dissent in Bowen, which is where this language was coming from, was drawing from Black's law, Black's.
But she uses a substantial adjective.
I think my understanding is that.
What is the government's definition of injures in this statute? Can you just give
We said injury is damage or substantial impairment to the use of the property is what was.
Okay, damage and substantial impairment are totally different things. So any substantial impairment is also going to be damage. Can you have a substantial impairment that's not damage?
I'm not sure, Your Honor, but again, whether the court accepts our definition or it doesn't, I don't know that we need to distinguish between those.
What your definition is, because the substantial, if you only modify one but not the other, then you might as well throw substantial impairment out because then you would just say damage. Well, we know it's not damage because Congress didn't use that word. It's used it in some other criminal statutes. So if the definition isn't damage, what is it and why?
I mean, that is our definition. I understand Your Honor disagrees with it.
What rule of law would allow us to read injures as damage or substantial impairment?
So let me find it. The rule of law is that those are the meanings attributed to it in common definitions such as Black's law, legal law dictionary.
No, did not have damage.
Just a moment, Your Honor, I was going to pull up.
Okay.
It was, I think, in.
The definition of injuries to a building.
So I understand to a building. I think maybe that is the disconnect we have here is that I believe so. I see we don't in our parenthetical cite the ultimate source, but
that's right. You don't need to do it here. I'm just getting kind of confused about what.
No, and I understand, Your Honor, but so I think, and maybe if I find it quickly, I will tell Your Honor. If I don't, I will move on.
1363 is just about property until the enhancement about life of the person. I get that, but in terms of what it
But that's even a
focuses
result
on
of the property action, so it's not, right.
And I apologize. I think, okay, here we go. I think, so Judge Bowen cited the criminal damage to property definition in Black's Law Dictionary is, I think, the original origin of the terminology that I was referencing.
Mr. Hale, is there, I mean, are there any common law cases you can point to that discuss this concept of injury to property? Is there any analog that uses that term? I mean, so when Congress adopted this term, if injuring a structure, conveyance, or real or personal property, is there a common law analog that can help us understand what injures means in this context?
I'm not aware of a case that's parsing it beyond the language that we've cited from Black's Law Dictionary, from restatements, from common law, which I understand just sort of raises the next question, which is if we're saying damage or substantial impairment to property, then what do those mean? I'm not aware of a case that parsed it as finely as some of the questions and the hypotheticals here today.
It's also, the statute also speaks in terms of, if you have both, the statute also speaks in terms of attempts or conspires. And I just say, if somebody has an email that says, you know what I think I might do tomorrow, I might go and spray paint a dot on the side of a building. That would be an attempt. And in order to be an attempt, it could potentially be an attempt. At some point, it would progress to the level of an attempt. And so the fact that Congress wanted to prohibit attempted injuries also makes me think that the injury is something other than a trifle.
I understand Your Honor's reading of that, but again, we would, one other point that I think is.
Law Dictionary does not use damage, just so you know. It is, as applied to a building, materially impair or destroy any part of the existing structure. I think damage makes things very confusing because that's for reasons known to Congress and not me, a verb that they have used in other statutes but didn't use here.
So I think the word damage then, in Judge McHugh's opinion, came from Black's Law Dictionary definition of injury. And he combined that with the criminal damage to property definition.
Yeah, it looks like she's citing 2014 Black's Law Dictionary.
I see.
She's not when the language is written.
I understand, Your Honor.
Can I ask you a question about the enhancement part of it? So I think we could have a debate about how much easier it gets if you get to do that the life of a person was placed in jeopardy. I mean, I think the other side would say not much easier at all. And you would say, actually, it's quite a bit easier if we can do that. But on the question of whether we can do that, 924C speaks in terms of whether something is an element. So we can put aside, there's an entire literature about divisibility and indivisibility and all that stuff. But really just 924C just asks on its text whether something is an element. And so the government's position is that for the enhancement, the fact that the building's a dwelling or the fact that the life of a person be placed in jeopardy is an element of a 1363.
Yes, Your Honor. I think the clearest path to getting there is the fact that it increases the maximum penalty.
It doesn't. As between the two. As between the two, that's what I'm talking about.
Well, so I think once we get to the point that the enhancement is an element.
The enhancement's definitely an element.
And then the question is whether it's divisible.
Right. I just resisting using I get lost when we use divisible and indivisible, but that's fine. We can do that. All I'm saying is, as between the building being a dwelling and the life of any person being placed in jeopardy, those are alternatives.
Yes.
Either of those satisfy the enhancement. The question is, are those elements? The enhancement writ large is an element, but you could instruct the element by saying, you, the jurors, need to find that either the building's a dwelling or the life of any person be in jeopardy. And actually, you all don't have to agree on which one it is. You could be evenly divided on which one it is. But as long as you agree on that one of them is satisfied, then you have the enhancement as an element, but each individual one of those is not itself an element.
And I apologize for using the terminology, but it's the terminology I'm familiar with and is in the case law. If the statute were found indivisible, that is correct. Our position is that the statute is divisible.
So on the question of whether it is divisible, which a court has to decide whether it's divisible.
Yes.
Then does the government, in a 1363 case, do you actually recommend that the jury be instructed that they have to be unanimous on whether it's a building is a dwelling or the life of the a person be in danger, one or the other, that the jury is instructed. So this is, you have to unanimously find A, or you have to unanimously find B in order for the enhancement.
They would have to be unanimous as to at least one of those. They could not be a mix, would be our position, yes.
Has the government ever, I'm sorry, has government ever proposed such a jury instruction in one of these cases?
I'm not aware of that issue, of anywhere where that issue has been litigated. And so I don't
I'm
believe so.
asking whether, if this is the government's view, then it should be proposing this jury instruction in every case under this statute.
I agree, Your Honor. I'm not aware of a case where that's been done. I would point to, sorry.
And then in this case, well, you were going to point to something. Go ahead. I cut you off.
I was going to point, and I understand that we would have a stronger position if that had been done. I would point, though, in the Catala decision that this court held, in that case, the jury was instructed on both the substantive offense and conspiracy as in the instruction construed it as one element. And even though it was done in that very case, this court held that based on its analysis of the statute itself, there were sufficient indications of divisibility to find that the way in which it was instructed was not determined.
We could do that, but I guess as between these two, the building being a dwelling and the life of a person being placed in jeopardy, the indictment in this case, the judgment in this case, they all spoke in terms of those two in the conjunctive. They said the building is a dwelling and the life of the person was placed in jeopardy, right?
That's right, Your Honor. And our position is we don't reach that stage of the Mathis analysis when it can be resolved based on an analysis of the statutory text of the statute.
I guess my point is, if those were actually, if it's divisible, which I think is the way you want it to be, right? Divisible.
Yes, Your Honor.
So that each of those is an element, then how they would be separate offenses. There would be an offense for doing these series of acts in a way that the building is a dwelling. And then there would be a different offense that would be doing it such that the life of a person be placed in jeopardy.
Yes.
So you wouldn't have a count that had both of those in the same count with an and.
A proper charging document and jury instruction would separate them.
Right. So that itself, I mean, the fact that the government charged it in this way seems to indicate to me that the government itself didn't think about these as each an element.
I think I would more characterize it as this wasn't an issue on anyone's radar, that was examined in that way, as opposed to a different thinking about it. But again, I would note, I mean, our position here, and I acknowledge it would be stronger if those record documents supported it. But our position and the way Mathis outlines the analysis is that what they call peeking at record documents in this case or other cases isn't a step you reach unless you can't resolve it by analyzing the statute using common tools of statutory interpretation and divisibility.
What are the common tools of statute? It can't just be that it says or, because that's true every time you're trying to decide whether something's a means or an element. What else is there? There's no difference in the penalty.
So in terms of the texting structure, we think that there are some things in our favor. The fact that it's fully offset by commas, that they comprise separate clauses, they're not modifying other elements. But we view critical in this case the fact that they cover alternatives in our view alternatives of radically distinct natures.
So and really the fact that the stuff that's bound up in each of those is pretty dramatically different. I mean, obviously they can coexist in a case like they do in this case, but you're saying the stuff that's covered by a dwelling is just different as a general matter and a pretty significant matter from the stuff that's covered by the life of a person being placed in jeopardy.
Yes, Your Honor. And we've identified multiple courts of appeals that have engaged in analysis along those lines.
Why are dwellings such a special building?
I'm not aware of legislative history speaking directly to that point, but if I were to speculate, Your Honor, I would say that, I mean, I think there's a long-standing principles in law of recognizing the place where someone's home where they live is a place of maximum protection of, security and safety, would be what I would venture.
To the building or to the person?
I think to both. Because the statute doesn't require that. I mean, the statute, the enhancement applies if it's a dwelling. I think someone coming home and finding their house sorry.
Yeah, I'm just sort of saying the reason dwelling's there is, at least my understanding, this is good old common law stuff, is that and robbery of a dwelling was always different, and that was because you're at much greater risk of people being there.
I think that's true,
but dwelling is right, and so if dwelling is there because there's a greater risk that a life will be put in jeopardy in that building than in other buildings, that's really, you got to admit, sort of what the common law was pretty clear.
I guess I push back. Oh, sorry. Go ahead.
I mean, that's just why that's been treated differently throughout back to England. I'm sure special protections, special, it's a more severe crime to rob a dwelling at night. People are going to be there. It's just much greater risk from that criminal activity than, a shed in the middle of the day.
I would push back a little bit on that, Your Honor. I mean, I think that might be part of it. I think the nature of it being a dwelling in a residence also carries a significant amount of weight, especially given that, especially in this context, I mean, if it was purely about where people are likely to be, I mean, in a context where it's a special maritime and territorial jurisdiction in the United States, I mean, you're covering military bases, embassies. I mean, you're covering places where there's
right.
But you're covering places. There are places that there are far more people than would be at a residence. But the statute still heightens the penalty for the residents and the dwelling, and I think that strikes more to the
I don't
nature.
think we disagree. I think the common law origins of dwelling having a special treatment are, as you said, at least in part, because there's a greater risk of people being there. And you just said it. And you added life of any person being placed in jeopardy because, well, we don't want to just get dwellings. We want to get office buildings. We want to get, the military bases where people are drilling, where our soldiers are. We want to get the schools where the kids are. I mean, that makes sense, but that suggests that there is some connection between these two.
I disagree, Your Honor, especially because if that were true, then the dwelling wouldn't be necessary. That would be encompassed in the endangering the lives of people. If that was all that it was driving at.
Right. Destroys isn't really needed here either. If
but a violation if a violation that endangered people's lives always encompassed dwellings, then they wouldn't have called that dwellings. I think dwelling as a specific type of property strikes more at if someone is not home but returns home and their home is now gone, has been destroyed, has been injured, has been damaged, that strikes a higher level, a level of harm that Congress had a special interest in including that enhancement. That is not true for a place of work.
Dwelling doesn't have that narrow a definition. Is a cardboard box in an alley that someone sleeps in a dwelling?
I don't know that it has that.
It is in the common law. I think courts have suggested that as long as there's a person that's there, it's a dwelling that lives in there. They don't have.
And I don't think that leads to a different outcome than I'm suggesting, though, Your Honor. Whatever it is that the place that the person lives in has special significance because it's the place that the person lives in. If the person loses the place where they live in, whether or not they were there, or the place that they live in gets injured or damaged or is lost, whether or not they were there when it happened, it raises a different level of harm, or as a different type of harm that Congress was interested in with this enhancement.
I mean, under 1363, the dwelling has to be a building. So at least we're talking about buildings by definition for purpose of the enhancement, I guess. And it does seem like there could be some overlap between those two, but I understand that your point is there's enough non-overlap that's why you see them, the alternates, as elements rather than as just alternate means of satisfying the enhancement.
And I think particularly instructive for the fact that there can be some overlap. We rely on the Fourth Circuit's case in Roof, which found divisible a statute that covered both the damage or destruction to religious real property or the obstruction of any person in the enjoyment of their free exercise of religious beliefs, because they found that those have such distinct natures. Of course, if someone damaged or destroyed religious property where someone was engaged in exercise of religious beliefs, you could violate both at the same time. But that isn't determinative where the natures of them are so, the language the court used was radically distinct, that they're not reasonably read as different means, but about different elements.
Make sure my colleagues don't have additional questions. Okay.
Well, then if there are no further questions, I know I'm well over time, Your Honor. We would ask for all, in addition for the reasons that we addressed on the other issues we didn't reach here today in our briefing, that the judgment of the district court be affirmed.
Thank you,
Your Honor.
counsel. Smillian, we'll give you 3 minutes for a rebuttal.
Thank you, Your Honors. A couple of points. First of all, to return to our earlier discussion about the quantum of force or quantum of injury required under 1363, I just want to point, and I apologize, I don't have all of this at my fingertips, but to 18 U.S.C. 1361, which is a similar statute to 1363, and it applies to injury or depredation to property, which is generally like very serious depredation to property. And that statute has been interpreted to cover things like defacing the US Capitol by pouring blood on it. So it encompasses relatively minor actions. Or at least, you know, I would think, I mean, pouring blood on the Capitol is a serious action, but it's not a violent one and wouldn't be a 924C crime of violence.
Depredation?
A depredation is a very serious term that like has a distinct common law meaning that's, oh gosh, I'm forgetting exactly what it is, but it's like seriously, I apologize. It's like pillaging. Thank you. It's like pillaging or something. It's depredation is a quite serious term, and in fact would be more serious than destroying. You're like running around and like pillaging whole villages. On maliciousness, which we also talked about, and whether a malicious action can be taken against your own property. Maliciousness is a term found in arson statutes as well, and in particular in 18 U.S.C. 844, which is the statute that many courts have interpreted to include one's own property. Those are the two big points I wanted to make. I know we've talked for a long time, but if there are additional questions, actually one additional point on the divisibility issue. I just want to note that I think the court's, some of the questions were absolutely right about how even if the court were to adopt a distinct natures test, we would prevail under it because of sort of the reasons that animate wanting to penalize someone for injury to, or putting someone's life at risk also apply to a dwelling. But I'd also point to this court's decision in Burwell, which I think really butts up against the distinct natures test. I mean, that the question was about the divisibility of the bank robbery statute and involved extortion, which has a very distinct nature from using force and violence to commit a robbery. And nevertheless, the court found that statute to be indivisible.
I mean, it is interesting though on that score, there's federal statutes and that may be one, I can't remember offhand, that specifically fold extortion into violence. I think there are some that where extortion is within something that's defined as a crime of violence.
Yes, so that's certainly true. I believe the sentencing guidelines do that. But it's both parties agreed and the court found that extortion, which can be committed by like, you know, threatening to reveal someone's indiscretions or something, is not a crime of violence under 924C.
I thought are there not statutes that define extortion to be a crime of violence? Maybe I'm wrong about that.
So there are, but then it's not a crime of violence under the elements clause. It's a crime of violence because it's an enumerated offense.
Right. And I'm just saying it's interesting that Congress would have thought that something it denominated as a crime of violence would include extortion, because extortion just doesn't connote the kinds of violence that we're normally thinking of, but Congress just decided that extortion is going to be deemed a crime of violence.
Yes. And it happens in the context of enumerated offenses, and often found in things like residual clauses, which is just a category of stuff that we're not dealing with at all here.
Okay. Thank you,
Thank you,
counsel. Thank you to both counsel. We'll take this case under submission.
Case number 24-1277 et al. Oncor Electric Delivery Company LLC petitioner versus National Labor Relations Board. Ms. Rogers for the petitioner, Ms. Sheehy for the respondent, Mr. Gillespie for the intervener.
Good morning, council. Ms. Rogers, please proceed when you're ready.
May it please the court. My name is Amber Rogers and I represent Oncor Electric Delivery. I'd like to reserve 3 minutes for rebuttal. The record in this case is devoid of any evidence, let alone substantial evidence, that Mr. Reed said anything to the Texas Senate Business and Commerce Committee, the media that was present, or the members of the public that indicated that the union and Oncor were engaged in an ongoing labor dispute. In fact, there was no labor dispute. And this ends the analysis under Jefferson Standard and requires that the board's decision be vacated. Importantly, on remand, the board got this correct and concluded that it was the general counsel's burden to establish this first prong. And in this case, it totally failed. It's worth noting 5 critical findings that are from Oncor 1 in this case in the decision from 2018. So Judge Williams, writing for the court, made or noted 5 critical findings that foreclose almost all of the board's arguments in this case. First, Judge Williams wrote that Mr. Reed never disclosed that his testimony was an attempt to gain any leverage in bargaining. Second, that the record gives very little indication of significant lobbying on smart meters in the years before Mr. Reed's testimony. Judge Williams noted that, stating that the email that was sent to a different committee from the one that Mr. Reed testified before that day. In regards to a bill that was no longer pending when he testified, and then also the emails that have been referenced as some sort of contextual background allegedly for his comments that day, but that email actually contained no overt nexus to any employee interest. Third, while the union opposed smart meters, largely related to automation issues that threatened a decline in the workforce, that was actually not a topic of Mr. Reed's testimony before the Texas Senate. Fourth, that Mr. Reed's testimony made no mention of worker hazards and made no detectable reference to worker risk. And then fifth, that so far as collective bargaining was concerned, smart meters were not an issue. So these are 5 critical findings that are the law of the case, and the board, despite continuing to argue against them, can't change what this court decided in Oncor 1.
Ms. Rogers, do you think it's fair to say that Oncor 1 required the board on remand to introduce some new evidence to meet the first prong of Jefferson Standard?
I think that's correct, Judge Rao, and it didn't, because there is no evidence. There was nothing new that they could. I think they came up with some somewhat creative ways to try to recast the other evidence, the prior evidence. But the reality is, Mr. Reed, we don't have to guess at what he said. It's in the record. He said what he said, and the law requires under Jefferson Standard that communication indicate to the third parties that there was some ongoing dispute. So there is no new evidence, and there was none that they cited or relied on.
And the remand was for the board to articulate principles, right? That would principles for affording protection to employees disparaging appeals to third parties. So we didn't say you had to come up with some more evidence.
No, I think the court gave some indications that if what you were relying on is, for instance, the leverage point that the court noted in Oncor 1, then you need to come up with some intelligible lines about how when a person says something like Mr. Reed did that is seemingly disparaging, how does that statement let third parties know that there is an ongoing labor dispute if there's not more to it? And I think the court then went on and gave a sentence about it would be unfair to let unions fly so close to the sun, I think, with making such statements. So I think the point was, though, and that was the next point I was going to make, Judge Millett, is this court did tell the board to draw some intelligible lines along, if you're going to say that a statement like this somehow that clearly doesn't reference an ongoing labor dispute does, what are those lines? And I don't think one can leave having read the board's decision and know what are those intelligible lines.
I understand that. So, but the point of the remand, I mean, it can't be that our opinion foreclosed a contrary ruling by the board on remand. Otherwise, there would have been no point to the remand. And they're experts in labor laws, so they may be able to understand or see connections that generalist judges can't. So we, send it back for them to apply their expertise to this record. And I understand now your argument is, and they didn't do it. But that's different from suggesting that what we said there really preordained or required a specific.
No, I think that's right. I don't think this court dictated an outcome, because you're correct. If you had, there would have been no reason to send it back to the board in the first place 7-8 years ago. I just think the court made some findings that the board can't get away from, which relate to things that Mr. Reed did not say. So there's a lot of discussion in the board's opinion about worker safety being an issue. And, I believe the law of the case is it's not. He said, if we read his testimony, he did not say that. There's nothing in there about.
If we take the underlying facts apart from what he said, put aside what he said, but if we take the underlying facts as a given in terms of what were the parties in discussions about, what were the kind of legislative proposals that were in play in previous cycles and things like that, is there anything that he could have said, in your view, that would have satisfied prong one?
Sure. I think.
What would that have been? So what would he have said?
Yeah, no, I think that's a great question. I think Mr. Reed could have said what I think the court noted was his purpose, right, was to gain leverage. He just didn't disclose that. And because of that reason, it's not protected. So I think he could have started off with, wow, he did. My name is Mr. Reed, or Bobby Reed. I work for Oncor. I'm a 34-year employee. We were negotiating yesterday and we're in a fight about wages. 2 seconds. And that would have disclosed that that the union was in a dispute, an ongoing dispute with Oncor about in a labor dispute, and then put the listeners on notice of that so that they're able to critically filter what he says.
So what he talks about then, even though what he talks about is about the safety of the smart meters, it doesn't have necessarily in your mind have to do with the subject of what the discussions between the union and the employer might have been. If he starts out and he says, I'm a union member, which he did, and then he says, and we're having discussions about wages, and I want to talk about the safety of the equipment that we have. That doesn't itself have any necessary nexus to wages. But you think if he discloses that he's in discussions with them on behalf of the union on wages, but then he goes on to talk about the safety of the equipment, then it's enough that the audience could say, okay, they're in a dispute about wages. I can't think immediately why that has to do with the safety of the equipment. I'm sure you can construct some economic sequence of events where it actually has a feedback loop, but I'm just not going to do that.
Right.
So I'm just going to think about these two things as kind of being unrelated, but he's going to disparage the safety of the product, and I'm still going to filter it in a particular way because they're in discussions about something that's totally different about wages.
Well,
you think that would have been brought within the...
And apologies for interrupting, Your Honor. I don't think it's just disclosing a topic that is a term and condition of employment. Mm-hmm. The dispute is the key. Because again, I could say something today, right? That is, very much related to a term and condition of my employment that, hey, Your Honors, I read a lot of cases to get prepared for today. You don't walk away from that knowing, am I in a dispute with Hunton about anything? I'm not, but but if you do reveal that we're not just in negotiations, but we're in a fight in negotiations, we want increase in wages, they don't. We want safety of smart meters, they don't.
And you think that's enough? As long as there's a dispute about something, it doesn't matter if it's related to the subject of the testimony or the appeal to because the idea behind Jefferson Standard, as I understood it, and Mountain Shadows, is that the statement makes an appeal to whoever the audience is to get help with respect to the dispute. But if you're talking about something that doesn't have anything to do with the dispute, then it's not entirely clear to me why noting that there's an ongoing dispute and then saying, we're in a dispute about wages, and then you say, oh, and by the way, I want to talk about the safety of the equipment. This equipment is horrendous. And why would that get the audience to help you with respect to wages?
No, and I do think the case law, and I'm trying to recall the name of the case right now, but that it does need to be tied to related to the dispute. It's not just saying anything, some argument that you're having. But here, I mean, again, I think it would be attenuated, but you could at least get to, we're in an argument about wages because we don't have enough people working on smart meters and safety. I mean, you could, again, sort of allude.
Maybe you don't need the nexus. I was just curious about your position. But if he had done something, it may be that you don't need it because you can disparage the employer in a way that's going to inure to your detriment with respect to whatever you're negotiating with them about. But if he had said, I'm here in my capacity as an employee and as a union member, and I could just tell you that we're worried. We are troublemen. We troublemen are worried because these meters catch on fire. And when we go on site, we don't want to get burned. And that's something, I mean, we may not be in an active negotiation with our employer about that, but it's obviously something that affects us. And we want to be in discussions with our employer about that. And our employer just seems generally insensitive to our injury in the workplace, including on assignment. If he would have done something like that, then that would have been.
Right, because I think it's the tail end of what you added that makes it a dispute, right? That again, just talking about an employee issue is not what the standard is. And it is alerting the third parties that you are in an ongoing labor dispute between the employee and the employers. That is the standard. And that hits on one topic that I wanted to raise, that again, what I feel is the board's arguments that are left in the case. And one of them is related to arguing that Mr. Reed testified about employee issues, which the board equates to being an ongoing labor dispute. And if we go back to the first oral argument, and it's around 29 and a half minutes into it, Judge Millett actually asked the counsel for general counsel, you said it relates to employee issues, but isn't the test whether it relates to an employee dispute? Is it enough under Jefferson Standard that it just relates to an employee issue? Where is the case where they have applied it to an employee issue that was not a dispute? And then the board attempted to get into a discussion about DirecTV, which Judge Millett correctly noted, like very clearly is about an employee dispute that was ongoing. And the employer itself admitted that the communications that the employees got into there indicated that they were in a dispute with the employees and the employer. But then Judge Millett asked the counsel for general counsel essentially a third time, that is there a case where there was an employee issue that was not an employee dispute that satisfied Jefferson Standard? And the counsel for general counsel conceded there are none. And we're in the same place, like 7 years from the court's decision. There has been no case that has come out that says that just talking about an employee issue versus an employee dispute with, an ongoing dispute with your employer satisfies the first prong of Jefferson Standard.
Can I ask a question about, I guess we have a case now because this is it. So,
right.
I'm trying to understand how explicit say the union member has to be, or the employee has to be about there being a dispute, right? You've hypothesized cases where they come out and say, and we are in a dispute. So this hearing, Oncor sent a witness too. So imagine, and this is just definitely not what the Oncor witness talked about in this case, to be clear on the record. But imagine you have a different record where a company witness comes and says, our new equipment is phenomenal, so easy to use, so easy to install. We've been sending out accountants. We don't even need our technicians to go out and install these things. Safe, easy, way to go. Needless to say, union members aren't happy with technical work like theirs getting sent out to accountants. So Oncor says that, and then Mr. Reed comes in and says, a lot of what he said here, but I think he talked about them not fitting into the bases properly, and the risks of that. And if he adds a line that says that in fact, trying to jigger it into the base can create electrical shocks for the technician. Would that be enough to create a dispute between employer and employee? Would that give enough context to the audience? So he's not saying, and we have a dispute with our employer about the accountants doing this. But looking at the context, the committee, the hearing as a whole, Oncor says easy peasy, accountants can do it and are doing it. They come in and go, no, well, accountants are losing their fingers. These things are shocking people. It's dangerous. And that everyone knows that's going to be, company says A and employee comes in and says B. Is that enough to create a dispute?
I think it gets you closer for sure.
That's why I asked the question. But now I'm asking you whether in your view.
Yeah, it definitely, I would agree with my friends on the other side that you don't need to use the specific, sort of niceties that maybe a lawyer would say of, this created an ongoing labor, I'm in an ongoing labor dispute with my employer. But I think in something like that, yeah, I think you're closer to, we're saying that these are great, they're awesome, they're amazing, and, accountant can do it, and I'm coming in saying the opposite, which is no, they can't, it's super dangerous. I think that gets you closer to it being a dispute, like letting the listeners.
Expertise could decide that was sufficient, assuming nothing else counteract.
Right. I think I think there's been some recent questions in other circuits for sure, not this circuit, as to the level of expertise that the board has on labor law, but yes, I think it could probably use that's some actual evidence in the record to say, okay, this could look like a dispute. A hearer could assume this is a dispute.
So had they done that here and gone back and pointed to something in Oncor's testimony, or I don't know who else testified?
No, I think they didn't because they can't.
Right,
I think so much of what this goes back to with Mr. Reed's testimony is, I think the board does a lot of talking in its decision and in their briefing about what they wish Mr. Reed had said, and drawing a lot of inferences from the things that he has said that aren't factual, and they don't show how you get to, again, using my example, Your Honors, I read a lot of cases, how do you then leap to Amber hates her job and she's in a fight with Hunton about wages? It's just, there's no context whatsoever that some person in this room could leave and take that from what I said. And that's sort of that's the equivalent of what Mr. Reed did. Did he talk about some things that he does at work? Sure, but did he put someone on notice that I am in a dispute with Oncor about these things, or the employees are in a dispute with Oncor about this? No. And again, I think the board is attempting to create, and I think the dissent notes this, just an entirely new standard, right? Which is sort of like a contextual standard, and I don't think the board can.
I had proposed a contextual standard, and this is one of the reasons I asked it, because I had read some of your briefing, including your reply brief to to say, look, we look at Mr. Reed's testimony. And that's it. And I wanted to understand whether that is your view, that nothing beyond the employee/union member's testimony can be considered, or whether, if it didn't seem like anything, that testimony alone, but then you back out and looked at broader context, that
No.
could suffice. Did you mean to say we're not allowed to look at anything beyond Mr. Reed's testimony?
I don't think you can, Your Honor, look at broader context unless Mr. Reed brought it to the listeners.
That didn't happen in my hypothetical.
And, well, I think he's giving some context about what they feel about it, or that it's dangerous.
What happens to be, yes, but that's not a context about a dispute. It's only because I said, and 3 witnesses before company representative testified, and then there's such a conflict between their
Right,
testimony. And it's
which-
a natural understanding for human beings that, okay, well, that's.
Well, which I think
They
why
are not on
my,
the same page here. And of course, employee safety is.
right, which I think why my
So you
answer
can look beyond just the testimony.
was equivocating, basically. Like, I think it gets you closer. I didn't.
Oh, I thought you got
No,
further
no,
than
I
that.
think it gets you closer, but than what Mr. Reed did,
Oh, so
but
is your answer
that's.
to my hypothetical now, no, that's not enough. We can only
No.
look at the employee's testimony.
Right. I think what the standard is, and, Jefferson Standard, Direct TV, Endicott, Mountain Shadows, it specifically says the communication indicated. And again, there's just
That's
no.
not, Jefferson Standard didn't just look at the content of the words on the bill. It added in the fact that, for example, if the bills had just been handed out on a picket line, that would be a pretty easy inference as to there's a dispute going on here. There's a picket line, but they had left these bills around town, unconnected to the union or the worker or the picket line. And so Jefferson Standard itself went beyond the words on the handbill and looked at the context of their placement. And the disassociation between that and any type of employee dispute. So I don't know how you can come back now and say, in my hypothetical, that loses because you can only look at the employee's testimony itself, because then you are going to have to require some kind of magic words.
Well, I think Jefferson Standard addresses that when it says just that, like, the fortuity of a labor dispute does not mean, so there may be something, but that still doesn't mean that you're making the third party aware of.
Because
of
they
that
were
dispute.
leaving these handbills around town. I mean, it just seems to me that we've got Supreme Court precedent looking at more than just the words communicated and deciding whether it conveyed the existence of a dispute or not. And yet you're saying we're only going to look at Mr. Reed's words. Now, it would be one thing to say, Mr. Reed's words don't do it and nothing else in the context of that hearing did. Right?
I mean, I think that's true.
Okay, well then,
Yeah.
that's all you need.
I think that's
We
true.
don't have to go to, you look only at the testimony. So I'm not sure why you would want to, fall on that sword, because.
Well, I think it's like, what else would you be looking at? I think our position is,
Testimony.
I think if you look at the things that the board is trying to rely on, if it's relying on that there was an email sent regarding smart meters in 2010, I think you could say that while arguably contextual, doesn't get you there. That, the fact that there were negotiations going on, that still doesn't get you there, because again, does the third party know what you're saying so that they can critically filter it?
I think it has to be based on what is reasonably viewed to be part of the communication in the ears of the listener. And if there can definitely be items that are beyond, nobody listens to somebody talk and says, I'm going to ignore every single thing I know about this person and about why we're here, and I'm only going to listen to the exact words they say, and then I'm going to forget about everything else. It's necessarily wrapped up in some context. It's just what's fair to take into account as part of the context. And if it's an example like Judge Millett has, where you have two people that are testifying right next to each other, it just seems baked into the testimony. Even what the words somebody chooses to use are based on what has immediately just been said by somebody else. You wouldn't say, And just so you realize it, I'm going to repeat verbatim what this person just said, and then I'm going to tell you how I'm responding. You're going to assume that you understand that there's a response. So I don't think it can be that you look purely at the four corners of the communication without thinking about the context at all. It's just what's fair to think that the listeners would have woven in to the communication that they saw.
But I don't think you get to jump to that the only logical conclusion is opposition. That I think it's untrue just to say that just because I'm in a union and speaking.
I might agree with you with that on that. I just think it strains credulity to think that you would only look at the four corners of the communication itself, divorced from the context in which the communication would have been understood by the listener.
Right. But if you're the listener at the hearing, if you're the media that was there, if you're just the citizen who testified before Mr. Reed, you don't hear what he said. And even if you were there for the Encore's witness who testified, you don't leave and hear that, oh, they're in a dispute about what?
You may well be right about that. I guess that may be true, that in this case, even taking account of the context, you wouldn't view his communication as sufficiently indicating to the listener that there's an ongoing labor dispute. I think the point is, though, there could be cases in which, even if the words themselves in naked of all context wouldn't necessarily connote that, it's going to be obvious from other things to the listener that that's going on. Jeffner Standard, there is a big difference between a bill that's handed out on a picket line and a bill that's, I think as the court itself referred to it, left in a barbershop. When the person in the barbershop picks up the handbill, they're not going to necessarily know. It did say it was the workers at the very bottom, but they're not going to know anything about an ongoing labor dispute. If you're handing out a bill on a picket line, I think you
right. And I think here you're testifying at a public hearing about the public safety of smart meters that I don't know, again, if you are the third party hearers, that you leave knowing, which is the general counsel's burden to do. They could have brought someone in to say, hey, I was there. I heard Mr. Reed and I took from it this, or they could have brought in a senator to say that.
You could definitely be right. You might well be right that in the context of this particular case, the surrounding circumstances wouldn't elevate the words that were used in a way that would bring it within the fold of the first prong of the Mountain Shadows test. But I think that's different from saying you never look outside the words that are used.
Yeah, I think it's hard to say never for any legal principle. I'm sorry.
I was just saying, sir, I did not take your argument to mean that context can never matter. It's just that the context here doesn't support any such inference.
That's exactly right. I think that is our position, is that the board attempts to use a lot of what the Oncor one called deep background. And again, we're not denying that these things happened. They did. He did receive an email a decade before he testified. He did engage in negotiations the day before he testified. Meter base had burned. Now we dispute the reason for it, but those things happened. But the reality is that we can read Mr. Reed's testimony, and he didn't say that to the listeners, which is the entire point of Jefferson Standard, is that if you are going to do something seemingly disparaging, make those types of comments about your employer's product or services, put the listener on notice of why, so that they can filter what you're saying.
Right. And your view is that nothing about the surrounding context would have alerted a listener to the fact that these facts that you ticked off that could have been mentioned, in fact, were effectively mentioned, because they just weren't. And you wouldn't immediately think, oh, he's saying this because he sent the same person sent an email X number of months or years ago. That's just not something the listener would have known unless it was brought to their attention.
I think that's correct. And then I'd also just point out from the case law, I don't believe the board can point you to any case that is going back a decade for context. it's not in any of the cases that Jefferson, because again, here, the union and the employer have a 70+ year relationship. How far back do you go to say, oh, yeah, well, they had a arbitration in 87 about this? Like, who would know that? And I think that's the problem. And that's the failure of the general counsel to not prove their burden on this issue.
Well, let's hear, unless my colleagues have further questions, we can hear from the board now, and we'll give you some time for rebuttal. Thank you.
Thank
Counsel.
you.
Is she?
Morning, Your Honors, and may it please the court. I think it's still morning. Barbara Sheehy for the National Labor Relations Board. I want to start with just making sure that it's clear that the board took up what the remand decision asked the court to do. The board said, as instructed by the court, we have thus described the conditions under which a reference to an employer practice could indicate a link to a labor dispute by finding that where an employee identifies himself as a longtime employee and a union rep, speaking directly on the negative impact of a product on his day-to-day working conditions, and further indicates that he has discussed these changes to working conditions with another union local, the indication prong has clearly been met. That's in footnote 10 of the board's decision and order. So I just want to highlight that at the beginning, because I do think that indicates very clearly that the board understood what this court asked it to do, and it took up that call and it answered the question. I want to start moving on. I think what's
His testimonies say that there is any risk to technicians in installing these.
I'm sorry, I missed the beginning of it. Are you asking, did his
Where does his
testimony?
testimony say there's any risk to the technicians in installing these smart meters?
Your Honor, he doesn't testify to that. And in fact, that even if he had, that wouldn't help us now, given the law of the case, where that was sort of foreclosed, I think, on the remand decision. So again, what the board is finding is the labor dispute is the change in his working conditions that are related to the smart meters. He testifies.
The change in working conditions.
The change is he testifies to the work orders, taking up the work orders, and then having.
Sorry, is it, I mean.
Sorry, I stepped away from the microphone. Sorry.
What you spend your time, how much you spend your time on which job is a change in working conditions?
So I think actually it's not just that he said that the work orders were changing and the type of work that he was being required to do as a trouble man going out. It's in also the context of the customer experience that there. And I think if we're going to go back and talk about what happened at the prior oral argument, I believe Judge Pillard noted in that argument during that time that there can be an overlap between the worker's interests and customers. So again, this also goes to another aspect, I think, of the Jefferson standard test. I'm sorry.
Whole finding, they implied that there was some sort of pattern of irate customers.
Yes.
Or haranguing the poor technicians. That's just not in his testimony. He references one instance where an elderly widow came out and he said, "You're going to have to make this payment." And her response is, "Well, I've been living here for 45 years and I've never had a problem until they installed that meter." Is that someone being irate?
So I think it's fair to say irate. I think disgruntled. I think the board also uses the word disgruntled.
At him?
I read that as disgruntled at the
Until they installed that meter, not you, until they.
Well, I mean, it could have been that two technicians went out and installed. I don't know that the plural versus singular, but I will say just.
Wow, I get to go back to my. We get briefs all the time, people complaining about past opinions maybe that I wrote, and much less politely than this lady. Am I being harangued?
I don't know that. I don't know that that's. I don't know about whether you're being harangued.
I mean, this just doesn't seem like irate. It seems, it could be disappointment, unhappy. Sure, nobody wants to pay more money, but it just doesn't feel like this is in any way a change in his working conditions. It's descriptive.
I would add that at the beginning.
More than descriptive of what she said?
I'm sorry?
Where did the board explain how this is anything more than just descriptive of what this woman said, that there's unhappy customers out there, maybe.
Right. I think
But no one's unhappy at him or them.
Right. No, but I think what's significant is not, so when he says, I can't tell you how many times I went out, and this is just, and then he finishes, so he tells his story, and it indicates very much in a similar way, I think, with DirecTV.
Well, how can't tell you how many times they went out seems actually, I don't know who put these paragraph breaks in here, but seems to really respond to the prior thing about, these work orders are coming in and it's on these meters burning up.
Right, but then he
Say how many times I went out on that.
Sure, but then he finishes and says, and that has just happened a lot. So I
It's
think,
not clear what that is, but let's assume it's elderly widow women coming to express their disappointment and having to play this. Is this, I mean, if you want to talk about someone haranguing an employee in a way that changes materially their job conditions, it's probably not going to be at least this woman and these words that I would reference. It seems, I don't know how from this factual record, no one disputes this is all he said. I mean, there's not even friggin' an exclamation mark after the sentence from, describing what she said. So that somehow this was, I mean, if not, they got the poshest customers otherwise in the history of all repair people.
I think it's a fair inference to draw from that, where the meters are burning up. We know that. He says that in his first part of his testimony. And then he relays a story about how he's having to go out and talk to people about, there's other testimony about some of prior in the public hearing that customers didn't want these meters. There's other testimony that
That
people
was
didn't.
because they were worried about the radio waves. It was not, did anyone else mention, any other witness mention the meter bases burning up? Or the meters?
I don't believe so. I don't
That
believe
was
so.
not their concern about why they didn't want them. They thought they were,
No, but if we're,
the waves or communications were going to be monitored or something like that.
right, but if we're talking about sort of disgruntled customers and he's saying, they're burning up, I'm going out, my work is changing. I'm having to deal with customers who are upset because they are now because now I'm going out to repair this. And I don't think it's an unreasonable inference for the board to have drawn from this testimony that he was relaying a negative experience related to an employment practice that this employer was implementing. He identifies himself also as a union
If I were
representative.
a lawyer, this would be the worst example I could ever come forward to try to show that someone was irate and haranguing employees. I can't.
I have the record that I have.
Uh-huh.
So.
I know, I'm just saying, you're saying it's a fair inference and I'm saying.
Right, no, but then I
don't even
think,
see it at all.
I know, but then let me.
This is not an example of haranguing or anyone targeting anything at him. He's saying, and maybe, this may be relevant information for this legislative body that's hearing this, that people don't like having to pay for this. Right? And that's fine for him to convey that information. It's just, there's limits on how. There's got to be a limit on when something's a fair inference from.
Absolutely,
But if this sentence is the only evidence in this entire hearing record from any of there was a dozen or so witnesses that testified of anybody being upset about this burning stuff going on. And she's not even that. She's not upset about the burning. She's upset about having to pay for the repair.
right, but that does go to a change in his job. I mean, she's having to pay for repair because the meters are burning up. So it is related. And so I do think it's difficult, I think.
So if she was upset. Oh, go ahead. I've talked enough. You go ahead.
No, go ahead.
If that's true, then her concern might have nothing to do with either her own safety or the safety of the employee. It could be an annoyance because she doesn't like the company logo. And the idea is, as long as there's some indication to a Senate committee that's dealing with the safety of the equipment, as I understand it, that a trouble man might get an annoyed customer for something just based on annoyance. Doesn't have anything to do with safety, doesn't have it to the customer, let alone to the troubleman. As long as there's some connotation that customers of the product might be annoyed or something, And then the employee can go on and disparage the product as much as they want. And the natural instinct on the part of the listener is, oh, you're talking about your relations with the employer and you're bringing us within the fold of that to help your cause in a dispute with your employer, because some customers are annoyed for reasons that have nothing to do with the product's safety.
I think that what your hypothetical isn't including also is that he does identify himself as a union representative at the beginning.
I think, and I don't discount that that's actually significant. I think that is different from Jefferson Standard. It's different from Mountain Shadow. It's different from other cases.
Right. He's not disassociating. There's no anonymity aspect to it. And then there's also the reference to the Houston local. But then I guess we're accepting all of.
But you're also not saying that every time a union member testifies about anything, the fact that they identify themselves as a union member means that everything they say is then satisfies prong one of Jefferson Standard.
I don't know that the board takes a position on that. It drops a footnote and says, as the law of the case, we are conducting this analysis under Jefferson Standard.
You think it might be the case that for purposes of the Jefferson Standard,
I know, right? Standard's good.
That as long as the person identifies themselves as a union member, then virtually in every situation, the first prong of the Mountain Shadows test, if I've got that name right, is satisfied.
I don't know that I'm taking that position that is a truth. The position that I'm taking is I don't think the board is by dropping that footnote to say that they are taking Jefferson Standard obligation analysis as law of the case makes me think that the board is reserving on the issue of whether they believe in maybe a different case where it's squarely presented and they're not bound by a remand decision, whether in front of a governmental body, a union official who identifies himself as such, whether that is sufficient to satisfy the first prong, certainly not giving them license then to say anything they want, because let's not forget there's prong two. So
right, but put aside prong two for now. But it sounds to me like what you're saying is, as long as a union member identifies themselves as a union member, and then anything they say thereafter can bear in some way on what their workday is like, including that a customer was upset about something, then it's protected by that. That's enough of an invocation that it's an indication to the audience that we need your help in the context of an ongoing labor dispute.
I don't think I would say that I'm characterizing as like literally anything that they can say, that they can say I wrote briefs today, for instance. I don't think that, because that's not this record. What we have here is he does raise issues related to his day-to-day work. This is what he does every single day. His job is to deal with customers. That has changed. He then says, I also talk to the other union local. So it's not, so I don't think it is strictly that. And I think the intended audience here, I think is quite important. The board points this out, the intended audience was this were the senators of the Texas legislature. They are very used to being lobbied. They understand that witnesses are there to advocate on their own behalf. So to the extent that we can't lose sight of the purpose of Jefferson Standard, which is basically like, have I given you enough information as the listener to understand that you can either discount my testimony or discount my communication a little bit because of some relationship I have going on sort of in the background here, or is it an enhancement for you depending on exactly what the communication is? So that I think when understood in that context where the purpose is just to make sure that the listener takes it with a grain of salt, understands employees testifying may have an axe to grind, in that regard, I think the identification of a person as a union representative carries a lot of weight. The board certainly hasn't, as far as I know, taken the position that that's sufficient. But I think understood in that context with the purpose of Jefferson Standard in the forefront, indicates that bar, and on top of that, the definition of an ongoing labor dispute is incredibly broad.
Isn't the view that that would be sufficient for someone to simply identify themselves as a union member? Wouldn't that principle be inconsistent with this court's decision in Oncor?
So I'm not suggesting that it is.
You said it was just law of the case.
But we have to do what you told us to do, right?
But not just in this case, like the general principles that are articulated, the holding of that case binds the board. I know the board has a frequent practice of non-acquiescence, but
Right, but
it's not just law of the case.
right, no, but it could be that if it in a different context, if it was presented where the general counsel was litigating strictly, I think we are satisfying prong one based on this employee identifying themselves as a union representative. And then the board, and I'm not saying the board is doing that, but if that case were then presented to the board would have the opportunity, notwithstanding this court's decision, because we don't know where jurisdiction is going to lie. We could end up in the Ninth Circuit or the Fifth Circuit, that the board could take the opportunity in that case to explain why it thinks, subject to judicial review, why it thinks it was sufficient in this type of proceeding again, it's normally government official proceedings. In that context, is that sufficient to satisfy prong one? To be clear, the board hasn't done that, but I don't know that this court's remand decision necessarily precludes the board from doing that if that case were to be presented before the
Can I
board.
ask you about the remedies here?
Sure.
So where in the NLRA does the board get the authority to impose the remedies that were imposed here?
Section 10C authorizes the board to take affirmative action that effectuates the policies of the act.
Affirmative action, but it refers to reinstatement and back pay, and it may not be exclusively reinstatement and back pay, but reinstatement and back pay are equitable remedies. And I think what's been ordered here arguably goes well beyond any equitable remedy.
So two responses to that. Your Honor is absolutely correct that reinstatement and back pay are traditionally equitable forms of relief, but they were listed as purely examples in the board's remedial authority. They're listed as examples. That's recognized by the Supreme Court that they don't have destructive significance for purposes of examining the board's authority under 10C. So the fact that they're listed, I don't think is necessarily just positive. And then on top of that, to the extent that the Supreme Court has drawn a distinction between legal and equitable relief, it is when it is in the statute when to draw that distinction, and there isn't a distinction in this statute drawing a difference between legal and equitable
Well, that's in the
remedies.
context of Article 3 courts, though. I mean, can you give me any example where an agency assumes the authority to impose a remedy that was not granted to them by Congress? I mean,
Oh, certainly. I mean, because that would
the NLRB is a creature of statute, doesn't have any underlying authority to adjudicate. That doesn't come directly from a statute.
right.
So the board has to be able to point to something specific that gives it the authority to impose these remedies.
Right, and I think, I don't think, quite honestly, that the court needs to resolve. I think there's an easier way to resolve whether the board acted within its statutory authority in granting direct or foreseeable pecuniary harms. In that, I don't think the court needs to decide whether it's equitable or legal and to what extent the board is limited in either pathway, because I think the board makes quite clear in its underlying Thrive decision that these types of back pay awards are equitable. They are ancillary
I've
to
read
the.
Thrive. I mean, Thrive just asserts that. It doesn't mean that they're in fact equitable.
Sure, the Ninth Circuit, Macy's, I would invite the court to have a look at that. Macy's court does find that they are equitable. To be fair, full disclosure, Third Circuit did not go in the same way. But I don't think the court needs to decide that. There's no meaningful distinction between a traditional back pay award and what the board did in Thrive. It is at its core, restoring the conditions to that which would have obtained but for the unfair labor practice. It is making employees whole. So to the extent it is.
The reason we don't have to decide it, and that is in May, the acting general counsel said, we're going with the dissent in Thrive. And we haven't had a compliance proceeding here. We don't know if anything other than back pay is going to be an issue in this case. It's not. Right?
Absolutely.
The board's no longer embracing
Well, to be
Thrive other than the dissent, beyond what the dissenting opinion did there.
To be clear, the general counsel's memo doesn't have the weight of a board decision. I don't think there's any reason to believe on the adjudication side of the board that we would see something.
It's going to get defended in court. Doesn't the general counsel get to decide that?
Oh, absolutely, absolutely.
Okay.
But
I mean, they can do what they want all day, but it doesn't get defended
they've
in
been
court. They're not gonna go anywhere.
But the board has imposed these Thrive remedies in this case. I don't take the general counsel's memo as being retroactively applied to.
Right. And I'm here, I'm here prepared to defend the
Wait,
Thrive.
what do you mean they've imposed it? Imposition happens in a separate compliance proceeding in board cases.
Yes.
Has there been a compliance proceeding?
There has not, Your Honor. No.
Okay. Do we have any idea what kinds of claims of remedies are even going to be sought in this case for
No,
Mr. Reed?
I would
Do
not
we know
know.
if he has anything other than back pay?
No, I do not know.
All right, so it's not remotely right. You haven't imposed them. You've said, here's what we do for remedies. Here's what we've said we do for remedies. That will apply in this case. Go figure out what's in this case.
And I would suggest that there's even a preliminary, an even easier way not to do it. I think this claim is jurisdictionally barred. We put that in the brief, that not having raised it to the board. So I think Your Honor is correct that there's perhaps a back end, I'm sorry.
Would there be review at the
Yes.
end of the process in the separate compliance?
Yes, separate compliance.
The same issue could
Yes,
come up again.
but it would
and
be,
resolved in
right, it
judicial
would,
review?
I guess it would be a little bit, it probably would be brought in a slightly different way. I'm assuming that would be related to a specific compliance specification. So the short answer is yes, they come to court if they're unhappy with whatever an administrative law judge has ordered in a compliance proceeding. But again, I think what we see here is sort of more akin to like a facial attack on a Thrive award.
So the compliance proceeding is just, I'm not sure exactly how this works in the board context, but is a compliance proceeding, it's the ALJ, I presume, figuring out what the damage is or what the back pay reinstatement actually, like what the amount is.
Right, well,
They're still applying the principle that was in the board's decision, which is that these types of, damages are available. Like
so
the ALJ is not determining again whether such remedies are available. They're just determining what amount
So
is under those remedies.
the employee would come forward with,
Just what amount or what the employee even seeks in that case?
I'm sorry, say that, I'm sorry.
It's not just the amount, it's what does the employee say the damage is worth?
Right, the employee comes forward and the region
So
acts.
Mr. Reed said the only thing I had my full-time job with the union, the only thing I want here is back pay. I
Yes.
don't know if he even wants reinstatement at this point. So if all he wants is back pay,
That's all.
that's all that it would be about. And we don't know what he wants, do we?
I do not know.
No, it's not in the record.
No, because
No.
we're not there yet. Right.
Right.
Yes.
I don't know.
Right.
I don't know how you can have facial attacks under this scheme here because they're not remotely ripe. We don't know that anything is going to be sought in this case or awarded in this case
Right.
that isn't anything beyond back pay.
That's correct, Your Honor.
Hasn't the general counsel here, though, in bringing the case to the board, suggested that these are the remedies that are appropriate?
No, I don't think that's fair because what happened here is the board in Thrive standardized what had been sort of a more ad hoc view of these types of what are now being called direct or foreseeable pecuniary harms. So it wasn't new. There were other instances. In fact, in this court, this court recognized in King Soopers a type of award like this, which was interim job searching expenses. So it hasn't always just been back pay. So what the board did is harmonize all of that, standardize all of that in Thrive. And here, the general counsel is only seeking what is now the standard remedy, which is, for now, what we're reading in the board decisions is, make whole relief to include direct or foreseeable pecuniary harms. But that is not a suggestion by the general counsel that he or she believed that in this case, there was a whole menu of direct or foreseeable pecuniary harms that we've never seen before outside of just back pay. It's just, they're seeking the standard remedy that is now what the board has.
The standardized language.
Yes.
It's no longer the standardized remedy after the memo. Is that right? Or
That I'm not sure about that because the memo, again, it's the board who issues the order. The general counsel is seeking the remedy. So I suppose I think we'd have to wait to see the board actually do something with the general counsel's recommendation for prosecution. If that makes sense. I think we'd have to wait to see that.
There has been no board decision adopting the reasoning of this May memo from the general counsel.
No, because we don't have a quorum. The board doesn't have a quorum right now. So there haven't been decisions that have issued recently. No.
My colleagues don't have additional questions.
Thank you, Your Honors. And again, we'd ask for full enforcement of the board's decision.
Thank you, Ms. Shi.
May it please the court.
Mr. Gillespie.
This is a very important case. Prong one of Jefferson Standard, to some degree, at the most important points in a union's life, tells unions whether or not their leaders can do things. Bobby Reed, he's here today. He's older now. He's retired now. But after being fired, he stayed on for a while as a business representative.
Mr. Gillespie, so
yes.
before we get to the merits, could you tell me why the union has standing to intervene in this case? So the
Yes,
union, I mean,
for
so the board ruled against Oncor. And so why does the board have standing for intervening on behalf of?
The union was the charging party. And when you're the charging party in a case, then at the hearing, at the ALJ hearing, I was the lawyer, the union's there and the union takes part. And the union actually takes part in the exceptions process that goes on to the board. And then if there is an appeal, or basically what we've got now, a petition for review and a petition to enforce, the union is commonly, it is a necessary party below.
I understand that the union has interests in the outcome of this case, right? But that's not sufficient for Article 3 standing. And interveners have to have Article 3 standing. So there has to be an injury. It has to be caused, by the party, by the party that's being sued. There has to be redressability. I mean, what would we do that could help the union here? The union effectively prevailed before the board.
The union has, right now, a living example of what can happen to you if you get up and stand in front of a Senate committee and testify on behalf of the union. And we've had several times, opposing counsel keeps referring to Bobby Reed as saying I'm a union member. He didn't say that.
Oh,
he said I'm
the board agreed with you.
IBW 69. I'm sorry.
So where's the injury though from the decision below? I mean, where is your standing?
The standing is that we oppose what the Oncor, the respondent or the petitioner is seeking. We weren't injured by the board's decision. We favor the board's decision. We would be injured if the Court of Appeals rules in favor of Oncor. We would be injured. Then the entire Section 7 of the NLRA is designed to protect union members when they exercise what are called, Section 7 rights. One of the fundamental Section 7 rights is to appeal to a legislator. There's Supreme Court authority on that. That's what Mr. Reed was doing. And this case actually touches on a couple of really huge things. Your Honor, you wrote the direct TV decision years ago. That decision, if you look at it, there were 33 words that were said to the press and 3 statements, 3 technicians, each had 1 statement, totals up to 33 words. And it was clearly a prong 1, yes, prong 1 was met. There was a connection to a labor dispute. The question in this case, I think we know that the burden is not onerous, a word I used to be able to say, and that there are no magic words required. So the question, and I think you've already focused on that, is did the committee get it? Were they in a position to understand what was going on? Well, you had Mr. Moore on behalf of Oncor sit there and say, smart meters are great, they're wonderful, let's let them go forward. And you had Bobby Reed, who didn't sign up as a union member. I'm sorry. He is a union member, but he signed up self and IBW Union Local 69. And then he testified, I am the union representative in Dallas and all over the state, talking about Texas. And he testified about how he contacted the Houston local to deal with this issue, the smart meter issue, the fact that they were causing problems. They were burning up. That's the vernacular they used. In fact, there was a technical issue. The meter bases themselves would overheat. And that caused a problem. Your Honor, you ask a series of fabulous questions, I think. I'm not trying to schmooze up to you much, but I make it a parallel analogy. My wife was a flight attendant for 36 years. My son is a flight attendant for 22 years right now, and I know that and I represent them. Union flight attendants. And I know that one of the issues they have on an airplane is when they deal with an unruly, unhappy customer. They don't have to be super unhappy, but it's a bad part of the job. It's a tough part of the job. It's something that is part of the job. It is a working condition. So when you go out and tell someone your meter base is part of your property, and in order for you to get your lights back on, you've got to pay the money, $1,000, $2,000, or else your lights can't come back on. And the board can reasonably infer that would be a disgruntled customer, and that's a working condition. And Your Honor, you wrote the decision in Ozzie, I always have a hard time saying this, when Ozzie Hesse Logistics LLC, not a prong one case, but it is a case dealing with the substantial evidence review. And in dealing with that case, Your Honor said we owe substantial deference to inferences drawn by the board from the factual record. Here, the factual record does include context. That's the other issue that is huge. And what I heard, I know I'm out of time, so I want to say this. I heard counsel for Oncor several times say that still doesn't get you there. Well, my goodness, what? You got to get there. I mean, if you're the head of the union and you go to Austin, Texas to testify and you sign up and you say things that the employer doesn't like so much that they're enraged at you and they fire you, they don't use progressive discipline. They take someone with a perfect record, an unblemished record, and fire that man. And here we are 12 years later and he's still fired. We need a remedy.
Thank you. Thank you, counsel. I'm sure my colleagues don't have additional questions. Thank you. Mr. Rogers, we'll give you 3 minutes for rebuttal.
Just a couple of brief points. One, it was raised about the poor elderly widow woman who has somehow over these years morphed into a disgruntled and irate person. And it's just, again, there's no record evidence of this. There's no record evidence that Oncor and its employees were in any dispute about irate and disgruntled customers. And I may have said this on my first comments, but again, this was brought up in the first oral argument. And Judge Millett asked, is there any evidence that within a year of the Senate hearing that the union was lobbying over employees having to put up with angry customers and the effect that has on their work environment within a year of this hearing? Counsel for General Counsel's response, no. Regarding the issue of Mr. Reed's position with the union, again, it's undisputed that is the role that he had. He was the union's business manager and financial secretary, but neither the board nor the union can point this court to any case law that says that means that satisfies Jefferson standard, that it's true. And I think there's a confusion that they are mixing up Section 7 rights with Section 10C, which is what Jefferson standard is looking towards, of whether or not you have to bring back an employee who was terminated for cause. So again, they can't point this court to any case law, board law, circuit court, or Supreme Court law that says that simply being a union member or the union president or steward or whatever position means that that is indicating a labor dispute. And I would in fact say goes as far as I think it's the board, for lack of a better phrase, letting it slip show that that there's a fundamental belief, right, with the board, which I think is diametrically opposed to the National Labor Relations Act, that the union and the employer are always opposed to each other. And that's just not true. The entire purpose of the NLRA is to have labor peace. In the majority of the time, employers and employees are actually not in a dispute. They have a collective bargaining agreement, and that's why. So I think the fundamental presumption that the board rests on, that just being in a union somehow indicates a dispute, is just factually and legally untrue.
Can I ask, I'm sorry to interrupt. I want to make sure you get to make your points. I just had a quick question though. And you may not know this, but does Texas have whistleblower protections that would apply separate and apart? So if you weren't in a dispute with the employer, but you wanted to reveal that there was some danger to a product, that would provide that protection? Or is the theory that the board is advancing here is when union members need to go complain about something inside the company to legislators, that has to be protected for obvious reasons?
Texas, I believe, does have a whistleblower act, and then there is some state case law regarding it's basically called the Sabine Pilot Doctrine after the name of the case, where an employee can, if they were terminated for violating so not for some discriminatory reason, but because your employer actually violate the law somehow, you could bring a cause of action that way.
Okay, I don't mean to take you off on something.
No.
I'm just trying to understand how, at some points it seems, if the board's concern here is that, whether it's within their wheelhouse or not is another question, but that union members need to be able to complain about dangerous products, there may be other schemes for dealing with that.
Well, and I think, I wouldn't say our position is against that. I think, again, that goes to a Section 7 right, which this court did decide that he was engaged in Section 7 activity when he testified. That's a different question than a Section 10C question that Jefferson Standard is trying to get to. I think union members can go to third parties if they want to advocate. But again, that's where Jefferson Standard swings in and says, if you're going to do that in a disparaging way, then you need to put the third party on notice that you're in an ongoing labor dispute, which one of the last points that I'll make here is, I think, again, the board and the union are attempting to graze over facts, right? And say that, well, the main audience is the Senate, and that's what's really important. You just ignore everybody else. No case law says that. The audience was the audience. The audience was the Senate.
Case law saying we look at the target audience. I mean, that's from us. Can't blame the board on that.
But the other people, I think the other people are the target too. The
board here found that the target was the legislatures themselves.
Well, because it's convenient for them to find that, but it's ignoring.
I'm not sure that's a fair point. I mean, we have said, we look at this, how would the target audience have understood what was being said? We've used that phrase, target audience. And so the board had to figure out who the target audience of this statement was. Now, the fact that other people can hear, if it was anyone who can hear, we wouldn't have said target audience.
Well, I think you're at a Senate hearing about the public, and the public is there. They're a part of the target audience. But if the target
audience had understood, let's just imagine they had a secret code, that was, all unions knew and all legislators knew that when a union member comes up and says, bingo, then I am telling you about a problem we have with our employer. But we don't always want to wash all the dirty linen in public. So they come up and say, bingo, target audience gets it. You're telling us about a dispute. You have a dispute. Our case law says we consider how the target audience would have understood it. That would be satisfied.
And that wouldn't work out for us, but yeah. But I think, again, even if we focus on the Senate being the target.
Your point. You're disparaging the product, and there's members of the public there that have the product, but that's just, be that as it may, we have a target audience test.
Right. And even if the Senate, the Texas Senate is the target audience, they were still told the same things, and they still weren't told all of this background contextual things that, again, we admit happened,
Sure.
but they weren't told these things.
Let me make sure my colleagues don't have any additional questions at this point. And okay, thank you, counsel.
Thank
To
you.
all counsel. We'll take this case under submission.
This honorable court under the direction of Monday, at 9:30 a.m.